public and my colleagues on the Judiciary Committee. I will begin with introductions in the order that I see people on my screen, beginning with Representative Moriarty.
Thank you, Mr. Chair. Good morning, all. I am Steve Moriarty. I live in Cumberland and represent my hometown together with part of Gray in House District 45.
Thank you, Representative. Representative Babbage.
Good morning, everyone, colleagues. My name is Christopher Babbage. I represent House District 8, which is 82% of the voters of residents of Kennebunk.
Thank you, Representative Thorne.
Good morning. Thank you, Mr. Chair. My name is Jim Thorne. I represent House District 103, which are the towns of Carmel, Herman, and a portion of Etna up in beautiful Penobscot County.
Thank you, Representative Poirier.
Thank you, Mr. Chair. I am Jennifer Poirier. I represent House District 107, which is all of Skowhegan and part of Madison.
Thank you, Senator Keim.
Good morning, everyone. My name is Lisa Keim, and I represent Senate District 18, which is northern Oxford County and two communities in Androscoggin.
Thank you very much, Senator. And my Senate co-chair, Senator Carney.
Good morning. My name's Ann Carney. I represent Senate District 29. That includes South Portland, Cape Elizabeth, and a little bit of Scarborough. It's nice to see everyone.
Thank you. And my name is Tom Harnett. I represent House District 83, which is the town of Farmingdale and the city of Gardner, where I reside. And I serve as the House Chair of Judiciary. And I see we've been joined by Representative Evangelos. Good morning, Representative. If you could introduce yourself, please.
Good morning, everyone. Jeffrey Evangelos, House District 91. I reside in Friendship.
Thank you, Representative Evangelos. Our work for today is divided in between to the morning and the afternoon. This morning, we have one public hearing on LD 1899. In the afternoon, we have presentations as part of Access to Justice Day, as well as two work sessions. But this morning will be focused exclusively on the public hearing. And I would ask the committee clerk to please call over the bill sponsor, Representative Jay McCrate. Good morning, Representative McCrate. It's very nice to see you. Welcome to the Judiciary Committee. I will now open the public hearing on LD 1899, an act to ensure safe entry and access for people seeking health care and other constitutional rights. And I'm pleased to introduce the bill sponsor, Representative McCrate.
Thank you, Mr. Chair. I'm happy to be back on Judiciary. Unfortunately, I can't bring chocolate because we're not in person. Senator Carney, Representative Harnett, esteemed members of the Judiciary Committee, I'm Jay McCrate, representing Harpswell, West Bath, and Northeast Brunswick in the House. And like Representative Thorne, I'm in Marine Resources simultaneously. I'm before you today to present LD 1899, an act to ensure safe entry and access for people seeking healthcare and other constitutional rights. I bring this bill forward to address a significant problem, that of patients' inability to access chosen healthcare safely when intentional barriers are erected to interfere with that access. While this proposal will protect patients' right to access to healthcare, it also protects the constitutional right of free speech and of protest. It's time that we enact a solution for a significant and long-standing problem. For more than a decade, patients and providers have had to navigate safe entry and disruptions to the delivery of care. These disruptions include protesters intentionally blocking entry and exit, screaming, ridiculing, and threatening patients, making noise so loud that patients are unable to hear or process critical medical information, and protesters refusing to socially distance or provide space for patients as they attempt to enter or exit a healthcare facility. Safe, unimpeded access to chosen healthcare must be a priority. Without the protection this bill provides, people can continue to be repeatedly and intentionally obstructed from receiving the healthcare they want and need. Testimony submitted will provide a number of firsthand experiences, including schools needing to change schedules to protect their students from harassment, and from providers who have had to help patients manage increased blood pressure and anxiety from the unrelenting interruptions coming from protesters. This bill proposal provides for the ability to establish and mark a medical safety zone of only 8 feet that will be in effect during the period of a healthcare facility's hours of operation. Violation of the medical safety zone could be charged as a Class E misdemeanor crime, comparable to criminal trespass. This proposal carefully balances the right of patients to receive health care free of unnecessary interference with the right of demonstrators to express their views regarding the health care being sought. Regardless of the healthcare choices a person makes, these are decisions that are between a patient and their healthcare provider and are not up to politicians or anyone who happens to disagree with the care sought. I submit to you that this bill is needed to provide a reasonable tool to address intentional barriers and bring greater safety and equity in access to healthcare. And just as a note, I did ask wonderful analysts to provide an amendment to the bill that you should have received, which just clarifies that that 8-foot medical safety zone described extends out from the center of the doorway of the facility. I've also included in my testimony information about what a Class E crime is and what the flexibility that is allowed in any disposition if someone is charged with a Class E crime. Thank you for your attention. I'll do my best to answer any questions.
Thank you very much, Representative McCrate, for bringing this bill forward and for being in front of the Judiciary Committee this morning. I will now turn to committee members to see if there are any questions for the bill's sponsor, Representative McCrate. Senator Keim.
Thank you. Good morning, Representative McCrate. I was wondering if you could tell me some instances where this has happened in Maine.
I think you'll hear more specifics coming after me, but there's a long history of interruptions at healthcare facilities providing reproductive health care. However, the bill is not specific to reproductive health care centers, but to all healthcare centers, because if someone is seeking care at a different facility that someone objects to, they could face the same intentional interference.
So you said there was a long history of people screaming and shouting and all of that. Is that documented in some way? Is there like police reports or whatnot?
Yeah, I think you'll hear from those after me about the specifics, but yes, thank you for that question. That's the point. This has been going on for a very long time, and we haven't had sufficient strategies to address it while still protecting constitutional rights of free speech and protest. So that's the aim here. Make sure people can get health care and make sure that people can state their views freely.
Okay. And then what if the 8 feet is in public property?
Well, this would be, municipality would be asked by a facility to put up this 8-foot barrier. It's actually not a barrier, a mark. Like it could be tape on the ground or paint, I think is what's recommended. And there would be a sign designating this as a medical safety zone. So it could be in a parking lot, could be right outside the doorway.
Okay, thank you.
Thanks.
Thank you, Senator Keim. Thank you for your responses, Representative McCrate. Are there additional questions from committee members for the bill sponsor? And I am not seeing any. So again, thank you very much for bringing this bill forward. It's our committee's practice that the bill sponsor is free to remain as a panelist for the duration of the public hearing. So feel free to do that if you would like. I will now turn to inquire if there are any co-sponsors of LD 1899 who wish to testify today. Seeing none, I would ask if there are any other members of the legislature who want to testify on LD 1899 today. And I am not seeing any. And before I proceed with the public hearing, Committee Clerk Panett, I see that Representative Lois Reckitt is in the attendee room. Could you please move our committee member over as a panelist before we continue with the public hearing on 1899? Welcome, Representative Reckitt. Sorry you were stuck outside the committee room. Please introduce yourself if you could. You're muted, Representative.
Legislature. Thank you. My name is Lois Reckitt, and I represent District 31, which is the ocean end of South Portland. Sorry that I appear to have misplaced the link at 11 o'clock last night when I was trying to get ready for this morning. So anyway, thanks for letting me in.
You're very welcome. Thank you for being here. And I see we've also been joined by our colleague, Representative Sheehan. Good morning, Representative. Could you please introduce yourself?
Good morning, everyone, and thank you, Mr. Chair. My name is Erin Sheehan, and I represent House District 12, which is downtown Biddeford.
Thank you, and it's nice to see you today. I will now turn to the attendee room, and as is our practice, we will call upon persons first wishing to testify in support of LD 1899, then those opposed, and then those testifying neither for nor against. As also is our practice, persons will be limited to 3 minutes of testimony. I will hold up my phone when there's about 15 to 20 seconds left, and then let you know when time has expired. But rest assured that committee members are free to ask you questions to solicit all information that you have on the bill. So with that, I ask for persons in the attendee room who wish to speak in support of LD 1899 to please raise your electronic hand. Thank you. And I will first ask the committee clerk to please move over Attorney General Aaron Fry. And Attorney General Fry, as soon as you are able, if you could activate your camera and your microphone. Welcome back to the Judiciary Committee, Attorney General Fry. It's nice to see you again. Please begin your 3-minute testimony as soon as you're comfortable.
Thank you very much. Good morning, members of the Judiciary Committee. My name is Aaron Fry. I serve as Maine's Attorney General. I appreciate this opportunity to offer my support for LD 1899 this morning. In my written testimony, I provide history on the relevant section here in Maine of the Maine Civil Rights Act. So I direct you there for some of that. My office has filed enforcement actions under the Civil Rights Act to protect both patients and protesters. In 2015, we filed our first enforcement action under the noise provisions that had been added back in 1995. This action was against a protester who had yelled so loudly outside of the Portland Planned Parenthood clinic that he could be heard in counseling rooms, disrupting a patient's right to receive the vital information about their medical options, including about the serious risks of potential side effects. So my office had defended those noise positions successfully in both state and federal court. Now, despite this successful defense of our law, there continues to be activity engaged at disrupting the clinic's services in Portland, where there have been efforts to evade this enforcement. I also provide examples in my written testimonies of these examples of where individuals have sought to evade the application of the Maine Civil Rights Act. So we believe that this bill, 1899, will provide a better ability to protect patients accessing these services at all healthcare facilities. The bill proposes the 8-foot medical safety zone from the facility entrance to ensure that patients can safely access the building, enter a confidential code if that's required. Federal courts have upheld buffer zones of up to 15 feet or more, indicating that they can pass constitutional muster. This bill also clarifies that the noise provisions only apply during operating hours and that a person who resumes making noise at the same volume that the person had used before receiving a warning may be sanctioned at any time after that order to cease that noise is given. So that way, if a person resumes noise at the same volume on a subsequent day, there's still the ability to act. Finally, this bill would deter conduct that violates the rights of patients by making intentional and knowing violations a Class E misdemeanor crime. Previously, the only remedy was a civil injunction, and typically they're requesting that the offender merely stay away from the facility would only amount to a civil violation. These civil remedies have so far proven ineffective in terminating the continued cycle of violations directed at reproductive health facilities. So again, I would refer the committee to my testimony for the examples of where my office has been engaged in addressing different conduct that's popped up over the last 30 years. Certainly happy to answer any questions, and we'll make sure to have subject matter experts here in the office available for the work session on this bill. Thanks very much for your consideration.
Thank you very much, Attorney General Fry. And before beginning questions from the committee, I'd like to welcome Representative Libby. Welcome to the committee today. Please introduce yourself when you have the chance.
Thank you, Mr. Chair. My name is Laura Libby, and I represent District 64, which is part of Auburn and Olive Minot.
Thank you. Attorney General Fry, I do have one question. It was asked earlier to the bill sponsor by Senator Keim about the history of incidents that have occurred in Maine. I know you discussed the state and federal lawsuits you had to file to enforce the noise portions of existing law, but can you just give us a brief history of other incidents that have occurred regarding interference with a person's ability to obtain health care and access health care?
Certainly. Two different parts to that response. First, my written testimony does indicate that over the last so many years, we have filed approximately 10 actions that protect both the First Amendment rights of anti-abortion protesters who are experiencing threats, acts of violence, property damage, and 2 actions against individuals who threaten violence against reproductive health care facilities. So I can get those specific actions that were filed to the committee for consideration. I don't have them before me now, but we do have that history of filing specific actions. Secondly, as my testimony references, we have seen conduct that has occurred after the successful litigation around the noise violations. What we see now is that individuals will engage in loud protest. They are warned. They then coordinate with a second person who comes in and engages in the same type of behavior that's loud. They are warned. They have a third person who comes in, engages in the same kind of behavior. So that's one example of where, in order to prevent any sort of effective enforcement of the current law, strategies have been employed. In addition, we just went through a pandemic. 6 feet was pretty much accepted by everybody as a reasonable distance in which you should not be interfering with a person's personal space. What we heard about in Portland, in particular, is that even that 6-foot public safety reasonable distance wasn't being respected by those who were seeking to exercise their First Amendment rights, which is fine, but in the balance of a person's ability to access their services. So we had learned about that conduct, which again is why it motivated some action, which I understand is contemplated by 1899. I can get those specific filings, by the way, to the committee. I'll have Leanne Robin, who's an AAG in the office, I'll have her forward those along.
Thank you very much, Attorney General Fry. Now we'll turn to committee members for questions for Attorney General Fry. Senator Carney.
Thank you. This may have already been covered, Attorney General, and welcome to the Judiciary Committee. May have been covered by your answer to Representative Harnett's questions, but I see in your testimony that you refer to 2 specific cases that your office litigated. I think one was in state court and one was in federal court. If you are able to, and I know you referred to getting the information to us, but if you're able to give us kind of a brief summary of the facts underlying those cases, because I think think it's important for us to understand kind of the factual basis for this legislation.
I want to make sure the committee has complete information. Leanne Robin had litigated that case. If it's all right, just so I don't make sure to miss something that's important to that case, because it was litigated over a significant period of time. I'd like to ask if I can have Leanne available for the work session to answer that question, and in the work that they did to uphold the Maine Civil Rights Act on that, and sort of what's happened since, because she's really at the front lines of how it's manifested, motivating the need for this bill. So again, I don't mean to deflect the answer. I want to make sure I provide a complete answer.
Thank you. That's fine.
And thank you for that offer, Attorney General Fry. We will take you up on that and have Assistant Attorney General Robin join us at the work session. Senator Keim.
Thank you. Good morning, Attorney General Fry. To follow up on that, as I was reading through the examples that you listed in your testimony, they seem to already be things that are against the law, such as, acts of violence and threats. So just the further information about whether or not these instances that you're bringing to us, if they are already against the law. And I wanted your comment as well on the bill language, and I was looking quickly to find the proposed amendment to see if it was still there, but the original language said that the facility, the healthcare facility, can request this 8-foot barrier, and the municipality has to comply. And I'm just wondering, though, what about when that is public property? Because, is a healthcare facility allowed to force a municipality to put a barrier up if it's public property and the municipality has no right to say no?
Thank you, Senator. I think for the second question first, to the extent that this is the balancing of rights, right? So the ability for an individual to express their First Amendment position about the appropriateness or inappropriateness of certain activity that somebody else might engage in, trying to convince them that that's inappropriate, balanced against somebody who has the right to access services relating to their own reproductive or other medical services that they want to access. And so the extent to which this conflict can occur on public or private property, there isn't anything that would prohibit this legislation or the law from indicating that there will be a zone in which a person that a person will be free from certain types of activities. So the public-private distinction here, I'm not, I'll certainly double check this with the team. I'm not aware of anything that would prohibit the legislature from indicating that there can be a zone that applies on public property, which of course is why the municipal law enforcement agency is involved in that process. As to the first question about whether or not the law currently covers the activity that's described in my testimony as examples of why 1899 may be needed, what we have seen is that there has been a development of the activity so that while the law might prohibit a person from yelling to the extent that they may be heard in a place in which a person's receiving services, presently the law only deals with that one person. They get a warning. If they come back the next day, that warning doesn't apply anymore, right? In addition, the law doesn't contemplate what happens when there's a coordinated effort stringing people along to engage in that same conduct. So this proposal in 1899 is developed to really recognize that we got a decision. It was a decision that recognized the balance of rights. And then on the First Amendment side, folks are trying different strategies to overcome the protected rights of those accessing medical services. So it's that balance that 1899 contemplates is not is not being fully recognized as contemplated by the original law.
Okay, thank you.
Thank you, Senator Keim. Thank you for your response, Attorney General Fry. Are there additional questions from committee members for the Attorney General? I am not seeing any. So again, thank you very much for your time and testimony today and for your providing us additional information as requested by committee members. Thank you. I will now go back to the attendee room and ask our committee clerk to please move over Desti Homan Sprague, Barbara Cray, and Marion Starkey. Desti Homan Sprague, as soon as you're able, if you could activate your video, thank you, and unmute your microphone. Welcome to the Judiciary Committee. It's nice to see you again. Please begin your 3-minute testimony as soon as you're comfortable.
Good morning, Representative Barnett, Senator Carney, and members of the committee. It's always a pleasure to be here with you. My name is Desti Homan Sprague. I joined today on behalf of the Maine Women's Lobby. We are here today in strong support of LD 1899 and thank Representative McCray for her sponsorship of this bill. Others coming after me can speak more specifically, as Attorney General Fry did, about specific cases and circumstances here. What I really would like to bring to the table is to say that the need for reproductive health care is expansive, lifelong, and affects almost everyone in the United States, in the world. We know that there are, hundreds of thousands of cases of reproductive cancer each year, that virtually every sexually active woman and virtually all men need to access contraceptive methods, that 1 in 4 women have had abortions. Most women give birth at least once in their lifetime. People develop STIs. And these cases are all receiving care in the kinds of clinics that are being addressed here today. We also know that there continue to be people chipping away at access to those services and setting barriers to those services, and that virtually all of those restrictions and limitations disproportionately harm women who are already marginalized or oppressed, poor women, women of color, rural women. And the kinds of stories that you'll hear this morning are another iteration of those barriers, not only legal and structural barriers, but in many cases, physical barriers, harassment, blockades, noxious odors, and other kinds of physical threats and harassment. That's particularly true in congested areas where services can only be accessed in public settings. One person's rights end where another person's rights begin. And the right to peacefully protest does not extend to interfering with the rights of others to access services. These kinds of physical threats and blockades are intended as an ongoing reminder that women's choices, experiences, and body are not fully her own, and that other people are entitled to make decisions about her agency. But we will not achieve gender equality until we acknowledge that the right to this care is essential for economic security and justice. We're in full support of this. And I would also like to share my own experience in accessing care following a miscarriage and subsequent D&C. I had the opportunity to drive to Augusta because I had my own car, but I still had to drive past the gauntlet of people waving signs at me, shouting at my car, and otherwise trying to intimidate, threaten, and harass me. It's simply not okay. And the fact that I had a car and I was able to drive past it in the privacy of my own home, we should not be asking other women to have to experience this kind of gauntlet. So thank you for your time today. I'm happy to answer any questions that you might have, and I hope that you will vote ought to pass on 1899.
Thank you very much for presenting your testimony and joining us today, Desti Homan Sprague. Are there questions from committee members for Desti? And I am not seeing any, so again, thank you very much for your time and testimony today. Next up, I have Barbara Cray. Barbara, if you could activate your video, unmute your microphone. Welcome to the Judiciary Committee. And please
Thank you.
begin your 3-minute testimony as soon as you are comfortable.
Thank you very much. And I am not a storyteller, and I'm anxious to hear those as well. I'm a member of the public who feels very strongly about passage of this bill. Thank you, Senator Carney, Representative Harnett, and esteemed members of the Judiciary Committee. I'm Barbara Cray. I'm from Westport Island, and I want to testify in favor of this bill. This bill essentially adds to the Human Rights Act of Maine the civil right to access health care at a healthcare facility without confrontation. That's a word I'm choosing to use. Confrontation is how I see what's happening. The act creates a medical safety zone and prohibits a person basically from entering into, remaining, or creating an obstruction in that zone. The act is content neutral because it prohibits being in a medical safety zone, except as specifically allowed by the statute, and thus has no regard as to the content of the speech. And the act is narrowly tailored to the legitimate needs and interests of the state in protecting the health and safety of its citizens by unimpeded access to healthcare facilities and therefore medical services, avoidance of trauma to the patients associated with that confrontation as they seek to enter the healthcare facility, ensuring public safety, and it does maintain the needs of law enforcement. Right now, the laws of Maine only prohibit physical obstruction of a building, which is basically defined as making it impossible and unreasonably difficult to get in or out of the building. This act protects the patient from confrontation in the medical safety zone. When a person seeking medical care, they often feel vulnerable. They are often young. They have often suffered prior trauma. They may be susceptible to fear. If confronted in some fashion as they try to enter that facility, they may not receive the necessary care because they're afraid, they're scared. They may not enter because they feel because of the fear they experience. That fear may impact their ability to communicate with their healthcare provider. It might raise their blood pressure. It might compound existing trauma. Or perhaps they receive care, but their fear of coming back for necessary follow-up care or future healthcare needs means they don't come back. This causes bad results for that person's partner and family. Receiving medical care should not be preceded by confrontation, by acts designed to scare or intimidate. The state's interest in protecting people is manifest, and I think particularly of young adult women. I certainly remember well myself my first visit to a clinic to obtain healthcare information as a young adult. It's a scary time. You're moving away from your pediatrician, thank goodness, and your parents' involvement, and you need to get information. And you have questions. And if you don't have a good trusted source to go to, you might ask your friends or your older siblings or resort to social media. All that's bad. That's why it's very important to be seen by a trusted medical professional, and this access cannot be limited. I also want to briefly mention that these clinics provide significant other healthcare services such as miscarriage treatment, HIV testing, STD testing, and also treatment for breast cancer and cervical cancer. So it's very important that these confronters be prohibited from being able to delay and access medical treatment. And I request that you vote that this ought to pass. Thank you.
Chair Harnett, we're not able to hear you.
I apologize. Thank you very much for your time and testimony, Barbara Cray. I am not seeing a copy of your testimony in our electronic file. Have you had a chance to file it, or could you do so after today's
Yes, I
hearing?
can.
Okay.
I will do that. Thank you.
Thank you very much, and thank you very much for being here with us today. Are there questions from committee members for Barbara Cray? And I am not seeing any. So again, thank you very much for your time and testimony. Next up, I welcome to the Judiciary Committee, Marion Starkey. Marion, welcome to the Judiciary Committee. As soon as you are comfortable, please begin your 3-minute testimony.
Thank you. Good morning. My name is Marion Starkey and I live in Falmouth. I've been a patient escort at Planned Parenthood of Northern New England in Portland since February of 2012. In that time, I've seen several groups of protesters phase in and out, showing up consistently every Friday morning for a year or two or more before being replaced by a new crop of protesters. During the 10 years that I've been escorting patients at the Portland Clinic, I've been called a murderer, sinner, an accomplice to murder, and have been told that I am wicked, evil, disgusting, and destined to burn in the fires of hell for all eternity. I've also been told that I'm loved and that I'm welcome at the protesters' church and that they would love to have coffee with me. It's quite a spectrum of verbal assaults and manipulations out there on Friday mornings. And while I understood that I would be exposing myself to verbal harassment when I signed up to be an escort, patients who make appointments for their health care do not do so with a similar understanding. Their shock, hesitation, and even terror upon turning the corner from Elm Street to Congress Street and seeing protesters and their signs lined up along the sidewalk in front of the clinic is heartbreaking. Of course, some patients pay the protesters no mind and confidently walk to the front door, even exchanging insults with particularly vocal protesters. But some patients are reticent to continue walking when they see what lies ahead. Having us greeters at the corner to walk with them helps, but they often still shrink into themselves during the walk through the gauntlet. And by the time we reach the door together, they are sometimes shedding tears. The signs that protesters hold and prop up against the building at 443 Congress portray images of fetuses at various stages of development, often mangled and dismembered. These images are captioned with text such as, "Mommy, please don't kill me," and "What about my body?" While the protesters say that they are present outside the clinic to counsel patients and to try to convince them to abandon their appointments and carry their pregnancies to term, their tactics appear to be intended to intimidate, shame, and punish women and their partners for the sin of having sex when they weren't prepared to get married, to get pregnant. This is especially ironic as many of the protesters have shared their own abortion stories with us escorts during our shifts. As if having to tolerate the walk past the protesters to get into the clinic weren't terrible enough, patients then have to hear protesters preaching from inside their exam rooms. Sometimes clinic staff call the police because being able to hear the shouting inside the clinic is a violation of the city's noise ordinance. When this happens, the police typically drive by with a window open and the protesters usually see them coming in time to quiet down. When the police officers do get out of their cruisers to address the protesters about their volume, the protesters politely say that they didn't realize how loud they were being and they would lower their volume. Once the police drive away, the protesters go right back to shouting, prompting the clinic to call the police again. Okay, I'm just a little, so I guess I'll just say I support the patient safety zone and noise ordinance enforcement because I care about access to healthcare. It's appalling that patients should have to endure the abusive circus that exists outside Planned Parenthood on Friday mornings. They are entitled to receiving healthcare without fear or intimidation, and they are currently not experiencing that right. So I urge the committee to pass this bill. Thank you.
Thank you very much, Marion Starkey, for presenting your testimony today. We appreciate your time. Are there questions from committee members for Marion Starkey? I will begin with Representative Evangelos.
Thank you, Chair Arnett. Good morning, Marion.
Morning.
Marion, I just learned something that I didn't know, so I wanted to confirm it. So Friday morning in Portland, there's a clinic open or some services open that people can access?
Yeah, so Friday mornings at the Planned Parenthood Clinic in Portland, Maine, in downtown Portland, is when I believe is when procedural abortions are scheduled. So not not specifically medication abortion services, which can be provided any day by any advanced health care provider.
That's very concerning to me because it just provides a targeted date and time. And you would think that our healthcare system would allow for your right to absolute privacy to access.
I mean, if I might address that, the protesters call the clinic call clinics all over America. There's a coordinated effort among anti-abortion protesters in the United States to thwart patients' ability to get care. And one of their tactics is to call and make fake appointments. And so that's how they find out the schedules at various clinics around the country, but they also, do a disservice to actual patients by clogging up the schedules with appointments that they never intend to go to. So regardless of what day of the week the appointments were, they would know.
Okay, thank you for that. Appreciate it.
Thank you, Representative Evangelos. Thank you for your response, Marion. Senator Carney.
Thank you. And Marion, thank you for providing testimony and for your volunteerism. Could you please describe for us how close the protesters come both to you and to patients who are trying to get healthcare as they approach the building and enter it?
They come as close as they can without touching us or the patients. So this has been especially concerning during the pandemic. We as volunteers are required to wear face coverings on the sidewalk, even though it's outdoors. The protesters do not wear face coverings. I've also heard many of them scoff at the vaccine. So presumably these are unvaccinated people shouting, singing, not wearing masks. And they, you know, again, we all understand that we're not allowed to touch each other. There's no physical contact, but they come right up to the patients. They've got pamphlets and little cards that they hand out to them that they're trying to kind of push on them as they walk down the sidewalk. Yeah, and they stand right next to us and get in the volunteers' faces and talk right at us.
Thank you, Senator. Do you have additional questions, Senator Carney?
As one follow-up, please, can you, like, are they a couple of feet away, a couple of inches away?
Sometimes it's inches. Yeah. There was an incident maybe 2 months ago now, where one of the protesters, a young man, just got right in the face of one of our volunteer greeters and started, shouting at him from 6 inches away from his face. And, we have a non-engagement policy at Planned Parenthood where we don't speak with the protesters. We try to not even acknowledge them if possible. And this particular volunteer felt like, he had to say, please step back. You're too close, because of how close this person was to his face during a pandemic.
Thank
you. And they're doing it to the patients as well. And they often, when patients pull up in their cars in front of the clinic, they'll go right over and kind of hunch over the doors and into the windows before the patients are even able to get out of the car. So it's intimidating.
Yeah, thank you for that additional information.
Thank you, Senator Carney, and thank you for your response, Marion. Representative Moriarty.
Thank you, Mr. Chair. I just have a comment to make. Having worked during the pre-pandemic period for many years in an office building just several numbers down from 442 Congress Street, I can tell you that I have personally observed exactly what Ms. Starkey has described.
Thank you, Representative Moriarty. Are there additional questions or comments from committee members? I am not seeing any. So on behalf of the Judiciary Committee, thank you very much for your time, testimony, and your answering questions from committee members. Thank you.
Thank you all for listening.
The next person I have to testify is Regina Rooney. Good morning, Regina. Welcome to the Judiciary Committee. As soon as you are comfortable, please begin your 3-minute testimony.
All right. Good morning, Senator Carney, Representative Harnett, and committee members. My name is Regina Rooney, and I'm speaking on behalf of the Maine Coalition to End Domestic Violence. And I've spoken with y'all before about the ways in which abusive people frequently coerce or force pregnancy as a way of trapping their victims within their control, and how efforts to restrict access to abortion and other reproductive health services end up playing into the hands of those people by both supporting and replicating their efforts to prohibit victims from exercising control over their own bodies and lives. So I'm happy to provide more context about that if it's useful. Maine's Domestic Abuse Homicide Review Panel has long recognized healthcare providers as having significant opportunities to intervene with survivors of abuse, and the US CDC names health services as playing a key role in preventing intimate partner violence. Now, MCADV deeply appreciates the work done by our partners in Maine's sexual and reproductive health field to provide supportive, identity-affirming, trauma-informed, and low-barrier care to their patients. Recognizing the many intersections between violence prevention and their work, they provide care that accounts for the impact of trauma in the lives of their patients, offering flexible cost services, educating themselves on domestic abuse, making warm referrals and connections between patients and advocates, and more. Unfortunately, they cannot control what happens outside their doors, and the survivors who come to seek their compassionate and trauma-informed care often encounter the kinds of barriers that you're hearing about today. To be clear, no one should have to endure being yelled at, grabbed, filmed against their will by strangers, blocked from accessing doors, or otherwise interfered with when accessing healthcare. But for survivors of abuse, this can remind them of other times they have experienced these same behaviors, since these are all common tactics used by abusive people. Having to relive those experiences while trying to access healthcare causes people harm, and it may be enough to deter them from accessing care altogether. And when they do get inside, it doesn't necessarily stop. And I just invite you to think about the examples you've heard today of the yelling and screaming and how that plays out for a person who is seeking support around their experience of ongoing abuse, perhaps getting a form of birth control that they can keep secret from their partner, or seeking an abortion because the pregnancy puts their plans to get free at risk. The activities of the protesters detract not only from the ability of the provider to offer the healthcare that that person needs, but also from their ability to provide the thoughtful screening support and referrals for domestic abuse that we rely on these providers for. MCDV supports the establishment of the patient safety zone. But we cannot support the enforcement mechanism named in the bill, which would expand Maine's criminal code. And we respectfully suggest that the committee explore options to enhance civil enforcement. Thank you, and I'm happy to answer any questions.
Thank you very much, Regina Rooney, for your time and testimony today. Are there questions from committee members for Regina Rooney? I am not seeing any, so again, thank you very much for your time and testimony.
Yeah.
Next up, I have Meredith Healy. Meredith, welcome to the Judiciary Committee. Please begin your 3-minute testimony as soon as you are comfortable.
Thank you. Senator Carney, Representative Harnett, and members of the Joint Standing Committee on the Judiciary. My name is Meredith Healy. I'm a registered nurse, and I serve as the Director of Healthcare Delivery for Planned Parenthood for Northern New England. I'm here to submit my testimony in support of LD 1899. While we experience protesting location at all of our main locations, my testimony will focus on our Portland Health Center, which is located on the 2nd floor at 443 Congress Street in downtown Portland. And patients access our facility by the sidewalk and through the main entrance. For 10 years, at least once a week, every week, protesters gather on the sidewalks outside of our building, yelling, aggressively preaching, and directly engaging passersby. They target women and young people entering the building who may not be coming to Planned Parenthood. This protest activity goes far beyond just holding posters or handing out literature. Protesters often obstruct access to the entrance, come in direct physical contact with those entering the building, and some yell so loudly that they can be heard in our exam and counseling rooms, which is incredibly disruptive to our ability to provide healthcare and is a violation of the state statute. At times, the interference from the protesters yelling on the sidewalk can cause our patients increased anxiety and stress. This anxiety can cause our patients to have elevated pulse and blood pressure, sometimes resulting in us needing to give them more increased amounts of medications to keep them comfortable. The disruptive activity is intended to and does directly impact the provision of care itself. Because the protesters are yelling and shouting, it can be heard in the exam rooms, and patients can have a really hard time focusing on critical information that is pertinent to their care, including the risks, benefits, and alternatives to procedures, as well as post-op information. Under the current law, when care is disrupted by the protests, we call the police. They respond, and they'll either issue a warning or talk to the protester that's responsible for this disruption. All too often, the same protester will engage in the same behavior once the police have left or when they return the following week. For some people or for protesters, that means that we've called the police dozens of times for repeated violations. It's taxing on patients and staff, and it does directly impact the care we provide. On other occasions, protesters will rotate in and out, violating the law until the police respond, and then when they leave, another one will start in. Over the course of time, this has effectively allowed a handful of protesters to disrupt care without any concern for consequences, and is directly undercutting the purpose and intent of this law. Due to the impact on patient care, we have instituted many interventions. We have a volunteer program so patients have a friendly face while walking the gauntlet of protesters. We've hired police officers to station themselves outside of the clinic. We have pursued other security measures to try to mitigate the experience for people entering and exiting the building with limited success. We've purchased white noise machines to reduce the interference from yelling. And we've even tried to use different parts of the health center in ways it was not designed, all in an effort to decrease the impacts on patients while they are receiving this care. LD 1899 would close the gaps in the current law, improving patients' ability to access care without violating a protester's First Amendment rights. By creating this clearly defined 8-foot medical safety zone around the entrance of the building in which patients receive health care, the bill gives patients and others accessing the building the breathing room that they need while allowing the protesters to continue their First Amendment rights to speech. No one should have to face fears of violence, harassment, intimidation, or threats when getting health care. Yet for more than a decade, protesters have harassed and intimidated Planned Parenthood patients and staff in ways that have impacted their care and threatened the health and safety of our patients and staff. I urge you to vote ought to pass on LD 1899.
Thank you very much, Meredith Healy, for taking the time to deliver your testimony today. The committee greatly appreciates it. Are there questions from committee members for Meredith Healy? I am not. Senator Carney.
Thank you, Chair Harnett, and thank you for being here today. I had a question about the impact on patients. You spoke about increased blood pressure and elevated pulse. Do you know whether that is being caused by running the gauntlet or by hearing the protesters in the medical treatment room, or both?
Honestly, probably both, but once patients have entered the building, they usually do tend to, start to be able to calm down a little bit. So I think that it probably happens multiple times. I know that we do check vital signs multiple times throughout visits. So we could check blood pressure and pulse before, and then have definitely had patients kind of be in a room where they can hear the protest activity and start to get upset. And, if we check another set of vital signs, they'll be increased again. So I think it probably happens. It does definitely happen at different points of the visit for those reasons.
Thank you.
May I ask a follow-up question?
Yes, you may, Senator.
I don't know if you heard the previous person who spoke regarding services that healthcare providers provide related to helping victims of domestic violence. Is that a kind of counseling that Planned Parenthood also provides to patients in conjunction with any type of medical care that you provide?
So we also have in Portland, we have what's called a patient support counselor. It's a social worker. It's a service that we offer that's entirely free to all of our patients to access. And it's really designed to help get them set up with outside resources, but they can also see that person for care or therapy for a certain amount of visits. That counseling room is also, unfortunately, adjacent to the street, and often those people are also who are there for therapy or to get set up with external resources are subjected to the noise from the protesters outside. But so yes, we do offer healthcare as well as mental health too. Does that answer your question?
It does. Thank you.
Great.
Thank you, Senator Carney, and thank you for your responses, Meredith Healy. Are there additional questions from committee members for Meredith Healy? Seeing none, again, thank you very much for taking the time and submitting testimony on this bill. We greatly appreciate your participation.
Thanks.
Next up, I have Lindsay Piper. Lindsay, welcome to the Judiciary Committee. As soon as you are comfortable, please begin your 3-minute testimony.
Good morning. Thank you. Senator Carney, Representative Harnett, and members of the Judiciary Committee. My name is Lindsay Piper. I use pronouns she and her. And I'm a women's health nurse practitioner at Maine Family Planning, which provides comprehensive sexual and reproductive health care including abortion care, statewide. I'm testifying in support of LD 1899. Thank you for this bill, and thank you for the opportunity to speak before you. Starting tomorrow, and for 40 days thereafter, anyone who works or seeks essential care at our Augusta Health Center will be forced to drive by anti-abortion protesters who stare down our patients, display gruesome imagery, and hold up signs that are offensive, stigmatizing, and incorrect on many levels. The teenager who needs birth control, the mom who needs abortion care, the friendly medical assistant going to work, they'll have to run a gauntlet of medically inaccurate and judgmental lies just to get to work or to a medical appointment. Legally, these hostile activities are contained to the public right-of-way outside and across from our parking lot. Still, our patients are affected by this harassment. They're making people feel horrible, one person wrote in our waiting room journal. I understand everyone has a right to speak their opinion, wrote another. I don't agree with false propaganda being waved in the faces of women making hard life decisions. One parent told us that they brought their daughter to Augusta Family Planning after she was sexually assaulted. Driving by the picketers to get to the office after being raped was intimidating for her and infuriating for me. The parent said, they don't know what each client's situation is and are inflicting additional fear after a horrific trauma. In their recently released report, 2020 Violence and Disruption Statistics, the National Abortion Federation found that between 2019 and 2020, abortion providers experienced a 117% increase in death threats and threats of harm, and a 125% increase in reports from National Abortion Federation member clinics of assault and battery outside of clinics. And this increased aggression is not limited to abortion care providers. Throughout the pandemic, we in the healthcare field have seen a sharp rise in intimidation, threats, and attacks toward people in the medical field, as reported by the American Medical Association and the World Health Organization. It is imperative that we all take steps in Maine to ensure patient and staff safety in healthcare delivery and in reproductive healthcare settings specifically. No one should face harassment or intimidation when accessing any form of healthcare. It's a matter of public safety and public health. For these reasons, on behalf of Maine Family Planning, I urge the committee to support LD 1899 and create a needed medical safety zone.
Thank you very much, Lindsay Piper, for taking the time to deliver your testimony and submitting it on file for the committee's review. We greatly appreciate your participation. Are there questions from committee members for Lindsay Piper? I am not seeing any, so again, thank you very much for your time today.
Thank you very much.
I'm going to head back to the attendee room to see if there are any persons who wish to speak in support of LD 1899. If so, please raise your electronic hand. And Ann Brandt, I would ask for the committee clerk to please move over Ann Brandt. And if you could activate your video when you are able so that we can see you. Thank you. Welcome to the Judiciary Committee. Once you are able to unmute your microphone, please begin your 3-minute testimony when you're comfortable.
There we go. Okay. Senator Carney, Representative Hartnett, and members of the Judiciary Committee, good morning. I'm testifying in support of LD 1899. I have been a volunteer greeter at the Portland Planned Parenthood Health Center since 2018. We wear vests identifying ourselves as volunteers for Planned Parenthood, and we stand outside the entrance of the clinic and open the doors for those entering the building. 2 of us also stand at the corner, and if a patient requests it, we escort them past the protesters from the corner to the entrance. In the last few years, I have witnessed many incidents of harassment and intimidation by the protesters of patients and others entering the building, including the following. Protesters will stand on either side of the sidewalk leading up to the entrance so that people going toward the building must walk a gauntlet between them. They're holding large signs showing bloody fetuses and yelling, "Don't murder your baby," at any woman who is going towards the building entrance. This happens every week that I have attended. I'm usually there 2 to 3 Fridays out of every month. Protesters standing next to the entrance and on the sidewalk directly in front of the entrance are yelling at the top of their lungs that abortion is murder, that God hates murderers, and that there is no forgiveness for those who commit abortion, and that those entering the building are going to hell. They are so loud that the Planned Parenthood volunteers who are standing at the entrance to open the doors have to wear earplugs because the noise is physically painful. Again, this happens every week. Protesters argue with women who tell them, the protesters, that they are just there to get a pap smear or other test, saying to those patients that they are complicit in murder because they are supporting Planned Parenthood by using their services. When passersby thank volunteers for being there or tell the protesters that they should not harass women coming there for health care, protesters will actually follow them down the street, screaming at them that they are just as guilty as the murderers inside because they support abortion. I have seen this happen most weeks. This creates a chaotic and frightening environment for patients coming toward the building. The area, the sidewalk area for many yards on either side of the entrance is pretty chaotic. During the pandemic, I think someone else has mentioned this, the protesters have not worn masks or socially distanced, and they are yelling. So again, this is frightening to those seeking healthcare who have to walk through and past them to get into the building because they are closer than 6 feet and they're yelling at them. There's usually one or more men who preach each week, giving a speech about the evils of abortion. One preacher yelled that if Planned Parenthood and those getting abortions were willing to commit murder, then it was morally right to kill them in order to protect the innocent babies. Another time, one of the preachers yelled about how his group was like abolitionists who were fighting to protect the lives of slaves in the 1800s, and that it was moral for abolitionists to commit violence in the Civil War to save the slaves. He then went on to say,
and I apologize, but your 3 minutes is up. So if you could wrap it up, but you will be available. Committee members are able to ask questions.
I'm sorry. Yes.
Okay.
So these are just a few examples of what I've seen. I will note that patients frequently are crying by the time they get to the door. And I appreciate you considering this bill and hope that you will pass it. Thank you.
Thank you very much for your time and testimony today, Ann Brandt, and the committee appreciates your participation. I did see that you registered to testify, but I haven't seen your written testimony in the electronic file. If you could submit that, that would be very helpful to have the complete record.
I will try to do that. I thought I had submitted that on Friday. It told me that it had accepted the submission, but I will send it again. Thank you.
That has happened to me on occasion, so I certainly understand. I now will open it up for committee questions. Representative Babbage.
Thank you, Mr. Chair. Ms. Brandt, yeah, I was going to check your written testimony, but I would, I am a former history teacher, and I would like you to share with us the historical parallel that you were about to mention with the abolitionists. Could you just clarify that for me?
Oh, the one of the protesters was talking about this. Well, he was yelling about it, and he was saying that the abolitionists, were willing to kill other people to prevent them from continuing to have slavery, and that commit violence in order to save the slaves. and that he and the other protesters were willing to commit violence to protect the innocent babies being murdered at Planned Parenthood.
Thank you. I appreciate you finishing that. Thank you.
Thank you, Representative Babbage. Senator Carney.
Thank you very much, Chair Harnett. And because this is such a fact-specific legislative proposal, I was wondering if you could continue to provide us with a couple more examples of the experiences that you have had as a volunteer.
I think I was almost finished before, but another thing that happened in the past few months was one of the protesters who stands close to the door and preaches started live streaming himself. He put his phone right across from the door there so that he could record himself speaking and record the scene there. And he was live streaming it. And this had the effect of recording the faces of all the women who were entering the clinic. This was just intimidating to a number of the women going in. And we started trying to stand next to the women and block the view of their faces as they entered the building. But again, it was a form of intimidation for the patients. At least that's how the patients were experiencing it.
Thank you. May I ask a follow-up, Chair Harnett?
Yes, you may, Senator.
Could you please describe to us how close the protesters, both those who are approaching people and those who are creating the gauntlet, how close they are to you as a volunteer and to people who are trying to get health care?
To me as a volunteer, I'm often at the front door there and they will stand next to me so they are this far away from me. For the people who are coming into the building, usually they will step up to them as though to speak to them. Well, they are speaking to them and try to hand them literature and try to engage them in conversation. Sometimes they will just step up to them and yell at them. But they'll be about this far from the patients.
May I ask one more follow-up?
Yes, you may.
Could you please describe how the patients react when that happens?
Some patients start to cry. Other patients are angry. And a lot of patients are confused and they just kind of get a little disoriented and they look to us. We're wearing bright pink vests and they look to us to say, where am I supposed to go? What I don't understand. And they just get a little disoriented. And some patients turn around and walk back towards the corner. So it depends on the patients. And some patients just yell at the protesters to get away from them. So it's a range of reactions.
Thank you for the additional information.
Thank you, Senator Carney, and thank you for your response. And Brant, I have two questions. One, well, maybe I guess it's three. How long have you been performing these volunteer duties?
I started in 2018.
And do you ever fear for your personal safety when you are engaging in this work?
Occasionally, yes.
Do the patients ever express to you that they are concerned about their personal safety?
Most of the patients I don't have conversations with. Our job is to get them in the building. A lot of times they will cry and they will say, what's happening and things like that, but we don't have long conversations. Okay. We get them in the building.
Thank you for your responses. Mm-hmm. Thank you very much for your time and testimony. Are there other questions from committee members?
So yes,
Representative Babbage.
Thank you, Mr. Chair. Ms. Brandt, thank you for your testimony. I should have asked this earlier, actually, but can you help me? Your experience is in Portland, is that right?
Yes, it is.
Yes. Can you help me to envision how this corridor, this medical safety zone, would be implemented? I know it's from the center of the front door, but the area at issue here, I believe, is the area between Elm Street and the front door. Is that right?
Well, that's the area where we're usually working. I'm not entirely sure of the specifics of 1899 as far as addressing a specific area in Portland.
Okay, it's not specific to Portland, but
yeah, that's what I thought.
But I wondered if how far from the front door the medical safety zone might be necessary or enforced. But you haven't spoken with anybody in Portland as to how that might happen.
I mean, I think the idea is maybe to have protesters maintain a space farther away from people who are coming into the clinic and from the door. I don't know specifically if they are also thinking like away from the building, or if they're just thinking that, you know, some people will still be able to be next to the building as long as they're not, you know, right next to the door. I think it would have to be addressed as to, you know, the meaning of the statute and how that would work out at that particular location. I think it's probably different for different locations.
Well, I thank you for that. And if anybody's listening, I would assume that each municipality would identify their own medical safety zone. But if that's not true, I'd like to hear from whomever. Thank you.
Representative Babbage, I noted that the bill sponsor raised her hand when you were asking the question. I think she might have raised it to respond to it. So Representative McCrate, if you had a response for Representative Babbage's question.
Thank you, Mr. Chair. Yes, it's 8 feet. It would be a semicircle. So from the center of the door out around to give an 8-foot margin, a safety zone, and again would be painted in that area. So the size is the same regardless of where the location, whatever center it might be focused at, but it's that semicircle shape. It's from at the door.
Okay, thank you. If Mr. Chair, may I follow up?
Yes, you may.
Thank you. Representative, thank you for bringing this forward. It's you know, the idea of intimidation has always bothered me, but my question here is the gauntlet that we speak of. May, you know, as I see the as I imagine the physical layout in Portland, for instance, there's probably a 30-foot space between the corner and the front door that I would imagine could be the gauntlet. I don't know if that's exactly, I haven't been there on a Friday morning, I don't believe, but is there protections that would be provided by this bill beyond 8 feet from the front door? Thank you.
The issue, Representative Babbage, is to protect.
Representative McCrate, we're having a difficult time hearing you. If you could get a little closer to your mic.
Oh, sorry. Is that better?
Yes, it is.
Okay, thanks. The issue is to balance the right of protest and free speech. So no, it would not, people would still be there able to protest as they choose to protest, but right at the door where people are trying to enter would be where the safety zone would be. And again, very, very carefully trying to balance those rights.
You're muted, Representative Babbage. Representative Babbage,
I'm trying to.
Okay.
I wanted to thank the representative. I wanted to thank the chair for allowing me that questioning.
You're very welcome. Representative Thorne.
Thank you, Mr. Chair. And I want to pose a question to the chair, if I could, that
Certainly.
I may not have the right schedule here because this says this is a public hearing and it feels more like a work session.
We allow.
Are we in a work session or a public hearing?
This is a public hearing in which the committee members are entitled to ask questions to those testifying.
Okay, because I remember the chair, Carney, reminding me I should only ask one more and then save all my questions for the work sessions. And it seems like today, everybody just asking multiple, and tell me more, and tell me about everything and tell me specific examples. And it just felt like a work session. So, okay, public hearing. Thank you.
You're welcome, sir. Senator Carney, you have a hand up in addition to your blue hand.
Yeah, I just wanted to clarify for Representative Thorne and other members of the public, when the bill sponsor is on the committee and will be with us during the work session, then typically we move on to questions to the members of the public who are waiting, rather than questioning the committee member who is the bill sponsor who will be with us for the work session. And I know that's a nuance that sometimes gets lost in translation, but I just wanted to clarify that. Thank you.
Thank you, Senator Carney. And do you have your hand up for an additional question, or you're all set? Representative Reckett.
Thank you. I'd like to ask a question before I open my mouth so I don't get in trouble, because I am a co-sponsor of this bill, and I think that means I'm not supposed to ask questions. Is that accurate?
We typically refrain from having the bill sponsor ask questions, but I will allow you to ask a question. Who is it directed towards? Is it
the woman who's Ann Branch.
Ann Brandt, I will allow a question, yes.
When you spoke about fear. And my question is related to that. Have there been, to your knowledge, other incidents other than shouting and being too close and all of those kinds of things happen in Maine of late? Or is this really the crux of the problem at this point? I asked that just because my own experience was a long time ago and was more than this. So I'm just questioning whether there is any more going on.
I will say that I personally have not encountered more than this.
Thank you.
Thank you, Representative Reckett. Representative Libby.
I actually am going to save my question for the work session. I think it's more appropriate for there, given that we've been reminded it is a public hearing and not a work session. Thank you, Mr. Chair.
Are there additional questions for Ann Brandt from committee members? I am not seeing any. I appreciate you as a member of the public being here to testify to the Judiciary Committee today and to answer our questions, recognizing that you might not be available for a work session. Thank you very much, ma'am. I will now turn to the attendee room and ask if there are any persons remaining who wish to testify in support of LD 1899. If so, please raise your electronic hand. I am not seeing any. I will ask if there are any persons in the attendee room who wish to speak in opposition to LD 1899. Please raise your electronic hand if so. And lastly, I would ask if there are any persons who wish to testify neither for nor against LD 1899. Please raise your electronic hand. And I am not seeing any. So with that, having heard from all persons who wish to testify on LD 1899, I now declare the public hearing on this matter closed. I thank the bill sponsor for Representative McCrate for bringing this bill forward, and to all those who participated in today's public process. Thank you very much. And committee members, we have a unusual situation where we actually have a break. This is the conclusion of our morning's work, unless somebody tells me otherwise when I'm finished talking. But our next item will be at 1 o'clock today, when we will begin our afternoon's work with presentations related to Access to Justice Day. Soupy, I saw you popped up. Did you have something to say?
Only, Mr. Chair, if you're done with the public hearing, when you close the public hearing, if I could have a minute.
Okay, the public hearing is closed, so you may have your minute.
Okay, I just wanted to thank committee members very much for sending me back your absentee votes and your voter and your jacket approvals. And for those that haven't, if you would please just check your last night's email and send them to me, I'd appreciate it. So thank you for the time.
Thank you very much. Representative Thorne, you have a question?
I'm not too proud to ask if I'm one of the ones that owe you anything. I am.
Yes, I sent out the jacket approvals, and I don't believe you have an absentee, but I do believe there are 2 jacket approvals that you need to send back to me if you would.
Okay, I'll look for those. Thank you.
Thank you.
Representative Libby and Senator Keim. Representative Libby.
I don't think anyone's going to be surprised to hear that I have the same question as Representative Thorne. I thought I was all caught up, but perhaps I am not.
I am missing one of your votes on 1972, Representative Libby, and I believe that was just, and then the 2 jacket approvals.
Thank you.
You're very welcome.
Thank you, Representative Libby. Thank you, Soupy. Senator Keim.
Just wanted to mention that if you're looking through your emails, Soupy puts the little exclamation point that high priority. So that way it's easy to recognize the things that really need our attention. So just thought I'd point that out for those that might have not noticed.
Thank you, Senator Keim. Is anything else, Soupy?
That is it for me right now. Thank you.
Okay, and Peggy, do you have anything for us at this time?
I did not. I was staying off camera because I didn't want you to think I had anything for you. But I will be tomorrow's a really big work session. So I will be sending you all the bill analyses and posting them for tomorrow. So look for all those. They will not have an exclamation mark next to them.
But that does not make them unimportant at all.
Right, but you can look at them if you want to for tomorrow's work session.
Thank you very much. And with that, we will come together again at 1 o'clock this afternoon. If you're going to keep your Zoom link open, just make sure you shut off your video and mute your microphone. Otherwise, we discover all sorts of family secrets. So take care and see you all.
See you soon.
Representative Moriarty, your mic is still on.
Hi, Representative Thorne. Hi, Representative Harnett.
Good afternoon.
Good afternoon.
Good afternoon, Senator.
This was kind of an ironic day at in marine resources, we had one bill this morning, which was $18.98.
Well, that's funny.
I imagine that has to do with the time it was submitted.
Looks like committee members are coming back. Hi, Representative Libby. Hi, Representative Babbage. We'll be starting up in just a minute.
Great.
And it looks like we have a quorum, and so we'll resume our work for this afternoon. Oops, excuse me. We'll resume our work for this afternoon, but actually I just have one quick thing that I need to attend to. One of our presenters for our 1 o'clock section of this afternoon's work is without internet, and I need to see if I can troubleshoot a little bit with that. I'll be right back. Hang on. And he actually is here, but he'll be speaking to us by phone. So let's begin with our afternoon work. And just as a reminder for members of the committee and also members of the public, we'll start with Access to Justice Day, which is our 1 o'clock presentation. We'll hear from a number of people working to improve access to justice for Mainers. And we'll have some time at the end for questions and answers. And then we'll have a work session on the Maine Commission for Indigent Legal Services starting at 2. And then at 4, we'll have a work session where we discuss with the Family Law Advisory Committee some research that they've done on in response to legislation in the first session about preliminary injunctions in family law matters. And so with that, I am going to bring over our first presenter for Access to Justice Day, and that is Justice Andrew Mead. And Supi, I signed out. Could you please either empower me, or if you could please move Justice Mead onto the panel? Thank you.
And here I am.
Just like magic.
Just like magic.
Yeah. Thank you so much for being with us this afternoon, Justice Mead.
Thank you. Are we ready to get started then?
I think we are. Yes,
Okay.
Go ahead.
Well, good afternoon, Senator Carney and Representative Harnett and distinguished members of the Joint Standing Committee on Judiciary. It's great to see you all once again, albeit in these little windows. I do look forward to the time when we can get together in person to talk about our matters of mutual concern. My name is Andrew Mead. I'm an Associate Justice of the Maine Supreme Judicial Court. It is also my honor to serve as the chair of the Maine Justice Action Group, also known as JAG. And one quick personnel note, Magistrate Judge John Rich who is the JAG Vice Chair, will soon be retiring from the federal judiciary. His successor, Karen Frank-Wolf, is actually with us here today in the group watching. So hello to you, soon to be Magistrate Judge Wolf. And I'm delighted to report that she has agreed to take over as the next Vice Chair of the Justice Action Group. So we thank Magistrate John Rich for his excellent service and look forward to working with Magistrate Judge Wolf.
Would you like me to bring Magistrate Judge Wolf over for you to introduce her?
It'd be wonderful. She could give you all a wave, and we can give all her a wave to formally welcome her, because you'll be seeing more of her and she'll be seeing more of you, no doubt, even though she's our federal colleague.
Okay, I think she's on her way.
And there she is.
Yeah.
Hi, Karen, can you give us all a wave?
I can. Thank you all for having me. I'm delighted to work with Justice Meade toward these important missions.
And we're delighted to have you on board. We're looking forward to working with you. So thank you, Madam Chair, for bringing her in to say hi. We're also joined by folks.
Thank you for joining us.
We also have some folks that you'll be seeing later, some representatives of Maine's exceptional civil legal services providers. They'll be addressing you shortly. They are Chet Randall from Pine Tree Legal Assistance, Deirdre Smith from the Cumberland Legal Aid Clinic, Sue Roche with the Immigrant Legal Advocacy Project, Robin Merrill from Maine Equal Justice, Liz Stout from the Volunteer Lawyers Project, Jay Martin from the Legal Services for the Elderly, and Charlie Dingman, who is our JAG Legislative Committee Chair. We're going to try and get all of that in within the allotted hour, so we'll do our best and go as fast as we can. I do want to say, though, in passing, without the slightest hesitation or reservation, these people are among the most decent, principled, committed, and humble people I've ever known. It's just such a profound privilege to work with them on access to justice issues. And I will mention, with a deep sense of sadness and loss, the recent passing of Nan Heald, the legendary leader of Pine Tree Legal Assistance for many decades. Her contributions to access to justice are immeasurable, as is the loss to our community with her passing. May she rest in peace and her memory being held in our hearts forever. Members of the committee, thank you for this opportunity to briefly address you once again on the occasion of Access to Justice Day at the Maine Legislature. My message is the same, but it bears repeating. Civil legal services are critical to our system of justice. In an ideal world, everyone would have access to legal assistance when confronted with conflicts governed by the law. But we are far from that ideal, very far. JAG is a judge-led coalition of organizations and individuals who are committed to justice, civil justice. Our members include state and federal judges, the University of Maine School of Law, the Maine Justice Foundation, the Maine State Bar Association, the Maine Trial Lawyers Association, the Maine Civil Legal Services Fund Commission, practicing attorneys, and others who are passionate about assisting all Maine people in obtaining equal access to justice under the law in civil matters. And JAG's membership also includes, of course, Maine's 6 principal civil legal services providers, the 6 organizations I mentioned in reference to the speakers a moment ago. JAG is committed to furthering the cause of seeking legal representation for your neediest constituents. JAG's primary missions include educating, informing, and raising awareness regarding civil legal services, as well as advocating for funding for civil legal services. That is why I am here today. And once again, I thank you for that opportunity. As just about everyone knows, indigent defendants in criminal matters are entitled, as a matter of constitutional law, to legal representation by attorneys. With a few very specific exceptions, that right has not been established in the context of civil cases, cases involving conflicts between private individuals, organizations, and government. So a defendant charged in criminal court with domestic abuse is entitled to a court-appointed lawyer. A victim seeking an order for protection from abuse in a civil court is not. It is estimated that approximately 75% of individuals involved in civil litigation are unrepresented. Not a day goes by for us when we don't see someday some manner of human tragedy unfolding in the civil courts of the state of Maine. People were caught in the quagmire of conflict and contention and strife, conflicts that threaten their families, their housing, their employment, their property, their health, and indeed sometimes their very lives. The law is complex, unfortunately, but necessarily so. For those who are unable to pay for legal representation and who are unfamiliar with the intricacies of the law, experiences in courts and legal conflicts are often perceived as injustice rather than justice. Unrepresented individuals, particularly those in the underserved populations, often come to court or to a legal conflict bewildered, frightened, distrusting, and consequently, they often make strategic and procedural mistakes that prolong the process and often lead to very unnecessary and unsatisfactory results. They leave those experiences alienated and cynical and convinced that the benefits of government and the law exist only for the affluent and the privileged. We must do everything in our power to push back against the disenfranchisement and marginalization that comes from unsatisfactory experiences within the legal system. We need to be a society that believes and acts on its often stated refrain that justice is for all. Civil legal services are at the centerpiece in that quest. We must invest in civil legal services. We are very fortunate to have legal services providers that communicate and they collaborate and they work together to avoid duplication of efforts or services. Their efforts range from self-help tools all the way to large-scale advocacy. Every dollar spent on their efforts is maximized to its full potential. Civil legal services providers get their funding from a variety of sources. So how far do those dollars go? Unfortunately, not far enough. Charlie Dingman will talk to you about the National Justice Index. The numbers in Maine are stark and disturbing. Charlie will share the raw numbers reflecting how many, indeed how few, requests for legal assistance can be met with current resources. On top of that, the COVID crisis has amplified the need for legal services to address the unique hardships and suffering that low-income people are experiencing during this pandemic. And my message today is utterly inadequate to fully convey the truly human picture of the need for civil legal services. The providers have a wealth of human stories, and I hope they will share them with you. From a purely court administrative point of view, make no mistake, the presence of attorneys in a case makes things go more smoothly, more efficiently, and less costly. And perhaps most importantly, the presence of attorneys serves the ultimate goal of justice. People can accept the fact that they haven't prevailed if they're confident that their voices were heard in a meaningful and knowledgeable way. As an aside, you should know that there's also a significant economic benefit to the Maine economy as a result of the investment in civil legal services. A 2015 study concluded that the positive financial impact of civil legal services totaled $37 million statewide and brought in many more federal dollars. The Maine Supreme Judicial Court has established the Katahdin Council Recognition Program to recognize those attorneys who have contributed 50 or more hours of pro bono services to Maine's underserved populations. The KC figures reflect that the private bar has stepped up and contributed 11,607 hours of pro bono services to Maine's underserved populations in 2021. And this results in a value of services in excess of $1.7 million. And may I say that our own Charlie Dingman was again one of those who qualified for Katahdin Council recognition, as he has in every year since its inception. Mm-hmm. Our civil legal services providers are currently caught in a perfect storm of funding shortfalls. COVID has increased the need for services and key grants have run out. The providers are deep into the lurch. A currently pending bill providing funding for civil legal services, LD 1326, will help address those urgent needs. And on behalf of the providers and myself, I fervently encourage you to support its passage. Finally, I offer the undeniable conclusion, a commitment to justice for all is a commitment to equal access to justice. Is there a higher calling? I don't think so. So I want to thank you for your time and attention. If it is agreeable to the chairs, our hope is to have the representatives from the providers speak to you in the order that I think Charlie proposed to you. And I think that the most efficient way to do that is to allow each speaker to hand off to the next one. And to the chairs, I ask you, would that be acceptable to you so we don't have to go through the formal introduction process?
That is perfectly fine.
Excellent.
And I think that Chet Randall, I don't know if you know this, is only able to participate by phone. And so I'm going to see if I can make it happen that he's able to speak. So you can go ahead and try to introduce him and see if that works.
All right, he is at the top of our batting order. Chet Randall is a distinguished member of the Pine Tree Legal Assistance Service of Assistances. And he will lead off if he's available. Chet, can you hear us and or see us? It may take a second to get him in, so I guess if there are any questions or comments, I would be happy to address them here as a filler. And I would like to do a special shout out to Representative Evangelos. Good to see you again. Thank you for your efforts that go above and beyond and the challenges you're up against.
Oh, thank you, Justice Mead. I'm doing fine. Don't worry. Everything's good.
Excellent. Thank you. Good to hear.
And I am not.
Can I?
Oh, great. Go ahead.
Oh, thank you. Thank you for your comments, Justice Mead. I apologize to the committee that I'm not able to participate by Zoom. My internet went down, and as things would have it, it did it in the last 15 minutes. So my apologies. Good afternoon, Senator Carney and Representative Harnett and members of the Judiciary Committee. My name is Chet Randall, and I am the acting Executive Director of Pine Tree Legal Assistance. I'm also a resident of Portland, where I've lived for over 20 years. Pine Tree Legal Assistance is Maine's oldest and largest provider of free legal services to low-income Maine residents with serious civil legal problems. It does not handle the cases eligible for court-appointed counsel through the Maine Commission on Indigent Legal Services. Pine Tree's cases involve housing issues, protections from domestic violence and sexual assault, financial stability, agricultural workers, Native Americans, veterans, and children's issues such as access to education. PTLA staff and volunteers provide legal help through a network of local offices based in Portland, Lewiston, Augusta, Bangor, Machias, and Presque Isle. Many of Pine Tree's clients are the working poor, people who work 40 hours a week in minimum wage jobs and support a spouse and children. Others are single parents trying to provide a stable family for their children. Some are adults with significant disabilities who are struggling to live independently. One particularly vulnerable population we serve are children. Pine Tree serves children in many ways. These include access to stable and safe housing, access to income, protection from domestic violence and sexual assault, and access to education. I'd like to share a brief story of a client that we served. In his second year of kindergarten, it was apparent that our client's son has significant speech delays. He had not been successful in reciting or memorizing the alphabet like his peers, and he was not meeting grade level standards. His low-income working parents contacted the Kids Legal Project at Pine Tree Legal Assistance for help understanding their son's rights and advocating for them. Our staff advised his parents of their rights, drafted a letter to the school to obtain appropriate testing, and worked with a literacy expert to help identify the strategies that would help him catch up with his peers. Our advocacy opened the door for him to begin receiving appropriate reading instruction at school and provide the opportunity to be a successful learner throughout his life. This case illustrates the impact of legal advocacy in securing positive educational outcomes for students of all ages, but particularly for young children. Through our work at Pine Tree Legal Assistance, we are able to help parents to better understand the available services and become more effective advocates for their children. Pine Tree Legal Assistance serves more than 6,000 households each year, but we turn away thousands more because we don't have the funding to serve them. Maine's legal aid community needs sustained and reliable funding to help children and families across Maine. I urge you to please invest in funding for civil legal aid. Thank you.
Justice Mead, should I bring over Deirdre Smith?
I believe she's next in the batting order, so if we don't get a handoff, if you would be kind enough to go down through the order, that would be great. Thank you.
I will do that. Thanks.
Good afternoon.
Welcome.
Thank you. Good afternoon, Senator Carney and Representative Harnett and distinguished members of the Joint Standing Committee on Judiciary. My name is Deirdre Smith. I'm a member of the faculty of the University of Maine School of Law, and I am the managing director of the law school's Cumberland Legal Aid Clinic.
I found this on the web for faculty.
Sorry. Siri trying to jump into the conversation, excuse me. So as many of you may know, the Cumberland Legal Aid Clinic has been a program of the University of Maine School of Law since 1970. The clinic is a statewide program. Our name is a vestige of its original scope. And it's a program through which Maine law students who are especially licensed under court and agency rules practice law as student attorneys under the close supervision of the clinic's faculty. The students provide legal help to hundreds of clients every year on a wide range of legal matters. And the clinic's mission is twofold: educating future attorneys through an intense clinical and mentoring experience while providing high quality free legal aid to indigent Maine residents. In one of the clinic's many programs, students provide holistic legal assistance to children and youth involved in the juvenile justice system. And this assistance may include advocating for their clients' educational rights, addressing an unstable or dangerous home situation, or ensuring that the clients have access to treatment. All of this with the aim of ensuring that these young people can complete their education and have successful transitions to adulthood and entries into the workforce. To give an example of this holistic approach, the clinic worked for a few years with a teen I'll call Seth. He was facing several juvenile charges and things were not going well in most areas of his life. He was not attending school, there was a lot of conflict at home, and he was struggling with an untreated substance use and mental health difficulties. Seth's student attorneys worked to build a team to help get him back on track. The first piece was lining up a good case manager, someone who could access services for Seth, and more importantly, who could earn the trust of Seth and his mother. And while monitoring progress on the services front, Seth's student attorney also worked on the legal front, such as filing a motion in court to protect Seth's constitutional rights when the student found problems with the investigation that had led to the charges. With his student attorney's help, Seth slowly turned pieces of his life around. A shift in his educational program allowed him to pursue vocational skills. Now interested and engaged, Seth became a solid student. As things at school improved, so did his life at home. And with Seth in a much better place, his student attorney approached the prosecutor with the pending motion and information about Seth's turnaround. All of the charges were dismissed. A young man whom many had given up on now has a clean record, a high school diploma, and he's heading off to an HVAC training program. And the student attorneys who worked with Seth each had an invaluable learning experience, which included a chance to see the positive effects that a lawyer can have on a young person's life. I just want to thank you all for your support of civil legal aid and the legal aid providers.
Thank you. Next, we'll hear from Sue Roach, who will be joining our panel.
Good afternoon.
Welcome.
Can you hear me? Yep. Okay, great. Sorry, I was muted and had to unmute myself. So good afternoon, Senator Carney, Representative Harnett, members of the Judiciary Committee. My name is Sue Roche, and I'm the Executive Director of the Immigrant Legal Advocacy Project, ILAP. ILAP is Maine's only statewide immigration legal aid organization. We have offices in Portland and Lewiston, and we also have a rural Maine project with an attorney who travels around the state to meet with clients and client communities. In addition to our staff attorneys, we also have a panel of over 200 pro bono lawyers who work on asylum and immigrant children's cases, donating over 4,000 hours of their time each year. We provide direct legal services to immigrants, helping them gain legal status, asylum protections, and work authorization. We also provide community education and outreach, and we participate in systemic advocacy to improve our immigration laws and policies, and also to provide our immigration law expertise on local and state issues that impact immigrants. Having a lawyer in an immigration case is really significant. Statistics show that someone with a lawyer is 5 times more likely to win their case and avoid deportation when they're in immigration court. And gaining legal status and work authorization are the first steps for an immigrant to integrate into Maine's economy and communities. Without that, they can't work, get a driver's license, they can't qualify for healthcare or feel safe in their communities. And we all know that immigrants are going to be continue to play an important role in Maine's workforce, growing workforce. ILAP helps clients in all stages of their lives, but I'd like to share the story of Samuel, who's one of the young people that we helped through our Immigrant Children's Project. This is a project that we launched in the fall of 2020, and it's a growing priority area as we've seen just dozens and dozens of young people, including unaccompanied minors, coming to Maine. And through this project, we partner with pro bono attorneys at Pretty Flaherty Law Firm, as well as our colleagues at the Cumberland Legal Aid Clinic and Pine Tree Legal Assistance, to help young people gain special immigrant juvenile status through an immigration process that requires state court action in addition to an approved immigration petition so that they can get a green card. Samuel grew up in a country in Central Africa where he was routinely beaten and neglected by both of his parents. When he was just a young teen, his mother brought him to the US and abandoned him in the care of a distant relative here in Maine. Free from his parents' abuse and supported by his community, Samuel really thrived. He became a standout student and athlete, but without the parental support, he lacked any guidance on his immigration case. And only when his college athletic scholarship was rescinded did he realize that he needed legal assistance. So he came to ILAP just before he was about to age out of being eligible for special immigrant juvenile status. So we were able to rush and worked with a pro bono attorney that we mentored to help prepare and file his case. And as a result, he was able to receive his green card this past year. And now he's able to pursue his college plans and his dreams for the future. So this is just one of many people that we're able to help through this project. And I believe that Robin Merrill from Maine, happy to answer any questions, but Robin Merrill from Maine Equal Justice, I believe, is going to go next.
Thank you. Yeah, and I think we'll hold questions till the end. I think that might be a good way. And if you can, you're welcome to stay on the panel. You can disable your camera as well, but we'll keep you on the panel for questions. Thank you.
Thanks a lot.
Thank you, Sue, and good afternoon, Senator Carney, Representative Harnett, esteemed members of the Judiciary Committee. It is very good to be with you today. I'm Robin Merrill, Executive Director with Maine Equal Justice, and I wanted to share a story with you to demonstrate some of the work that we do to reduce child poverty and strengthen Maine's workforce. I also wanted to share a story about a Sam, and this is Samantha from Parsonsfield, who wanted to go to college to pursue a nursing degree. And as a single mom receiving cash assistance from TANF, Sam saw education as a pathway out of poverty. So Samantha learned about the Parents as Scholars program. This was back in 2016. Parents as Scholars is a program that was developed by Maine Equal Justice back in 1997. And Parents as Scholars really makes higher education and training possible for low-income parents who are juggling a lot, helping with necessary supports like childcare and transportation that can make going back to school and successfully completing an education possible for parents. Maine Equal Justice helped Samantha to access Parents as Scholars when she reached out to our legal services team. She was having difficulty accessing it, and she was able to then enroll in the program and go back to school. Sam was a strong self-advocate who reached out to us for help, but she knew that there were many other parents like her who were missing out on this opportunity. And she didn't want others to struggle like she did. And, subsequently miss out on their dreams. Samantha joined the Equal Justice Partner Circle, which is a leadership development program for people with low income to further develop her advocacy skills. And then back in 2017, Maine Equal Justice convened business and faith leaders state and local chambers of commerce, social service agencies, and other stakeholders to advance the Invest in Tomorrow initiative, which really focuses on both reducing child poverty and bolstering Maine's workforce. Samantha supported reforms that came out of this effort to help other families like hers. And after hearing from many people like Samantha, the legislature passed bipartisan reform measures to lift thousands of families out of poverty, including the creation of the Higher Opportunity and Pathways to Employment program, appropriately known as HOPE, in 2018, that makes education and training possible for low-income families who are not TANF eligible. So HOPE is now making school possible for hundreds of families throughout the state, most of whom are entering the healthcare field to fill jobs in Maine that we desperately need filled. As for Samantha, she graduated from nursing school at USM and is now employed as a nurse, providing for her family and her own financial security, as well as the health of many Maine people. Maine Equal Justice works with people like Samantha to increase economic security, opportunity, and equity for Maine people. We provide direct legal assistance to help people meet their basic needs, education and training to ensure people can access help that is available to them. And we work to advance solutions that we all have a stake in to address child poverty and strengthen Maine's workforce. Thank you for listening. I'm happy to answer any questions you might have. And I'm also ready to pass the baton to Liz Stout, who's the Executive Director at the Volunteer Lawyers Project.
Many thanks, and Liz is on her way.
Thank you.
Hello.
Welcome.
Now you can hear me. That's wonderful. Thank you so much, Senator Carney and Representative Harnett and members of the Judiciary Committee. Thank you so much for the opportunity to speak with you today. My name is Elizabeth Stout, and I am the Executive Director of the Maine Volunteer Lawyers Project. I would like to talk with you for a few minutes about workforce issues and how legal aid impacts those issues. Legal aid plays an important role in providing stability and support for workers and businesses in Maine. At VLP, we do a lot of work assisting survivors of domestic violence and families with other types of family problems, and we do provide legal assistance in protection from abuse matters and family matters to people across the state. But while many people do come to us for help with family law, we find that there are many other areas of legal need, including housing, employment, consumer debt, and disability that have a major impact on the ability of a person to be able to work and provide for their family. VLP is there to try to meet that need by connecting people to volunteer attorneys in employment and employment law and related matters. One example is a woman I'll call Lindsay, who was referred to VLP from the Sexual Assault Prevention and Response Services last fall. In addition to dealing with being a victim of assault, Lindsay also faced a claim of overpayment of her unemployment benefits. VLP was able to find an attorney willing to donate their time for free to assist with this unemployment issue, adding financial stability to an otherwise very difficult situation. In response to increased need at the onset of the pandemic, when many people reached out to us for help on employment-related issues, VLP expanded our employment law clinic to a statewide resource, where it was previously available only in Portland. Workers had many worries about workplace safety in the time of COVID, and the clinic played a critical role for people who wanted to know about their rights, but really did not want to bring a lawsuit against their employer. Another example of how VLP has supported workers was a case involving a group of Somali workers who were not being paid by their large employer. Through the employment law clinic, they were referred to a volunteer lawyer who was able to advocate for and successfully achieve payment of most of the wages that they were owed. Without the clinic, including multilingual support, it's unlikely that they would have been able to navigate this process on their own. In addition, VLP has had many requests for help from owners of small businesses who struggled with pandemic-related workforce decisions. In response, the Volunteer Lawyers Project recruited a team of volunteer business lawyers and connected those small business owners with pro bono lawyers for help and advice in that difficult time. These are just a few examples of how legal aid and the VLP supports workforce needs and helps people secure financial stability in challenging times. I so appreciate your time and attention today, and I thank you for your support of legal aid in Maine. And at this time, I will hand it over to Jay Martin from Legal Services for the Elderly.
Thank you, and she is on her way.
Good afternoon, everyone.
Welcome.
Senator Carney, Representative Harnett, and distinguished members of the Joint Standing Committee on Judiciary. I'm Jay Martin, as you already know, Executive Director of Legal Services for the Elderly. First, I want to thank you so much for your focus today on the importance of access to justice. LSC is a statewide organization that provides free legal help to older Mainers when their basic human needs are at stake. This includes things like housing and public benefits, consumer rights, and personal safety. For older Mainers living on fixed incomes, unresolved legal problems become tipping points in an otherwise stable life if an attorney is not available to help when help is needed. Some of the most compelling work that all of the providers do is focused on helping people restore their safety when they face abuse or exploitation, and that is certainly true for LSE. It's estimated that 1 in 9 people age 60 or older face abuse, neglect, or exploitation every year. And unfortunately, much of that perpetrated by family members, someone the person trusts. LSE has been representing victims of elder abuse for over 45 years. And I want to share just one story with you today about our work in that area. Joe, a World War II veteran, sought help from LSE after his daughter refused to allow him access to his own money. Joe had suffered 2 strokes, and he was in a wheelchair, and he was homebound. But he had a good life. He spent a lot of time with his friends and his family. After his wife passed, he decided he'd buy a mobile home, and his daughter moved in to help him. He named her agent under his power of attorney and added her to the title of the home and his bank accounts. But once in the home, the daughter took steps to isolate Joe from his friends and his family. She moved her boyfriend into the home. She taunted Joe and repeatedly told him no one loved him or cared what happened to him. Joe tolerated the verbal abuse, but he became increasingly upset when she started to refuse to give him money to buy gifts for his grandchildren or pizza. When he sought help from LSE, he thought he had $25,000 in his savings account. The LSE attorney quickly determined that there was $15 in Joe's account. Joe was devastated. Bank records revealed that his daughter had taken all of his money for her personal use, opened and charged thousands on credit cards in his name, and even purchased a new car using the power of attorney document to make him co-signer. Joe knew his money was long gone, but he wanted his daughter and her boyfriend evicted, and he wanted her off the title to his home. LSE was able to evict the daughter, clear the title to Joe's home, and clear his credit history. We also were able to refer Joe for a home health assessment to get him the help he needed in his home. Because Joe got the legal help he needed when he needed it, he was once again able to make his own choices. And he went back to doing things like playing cards with his friends and buying gifts for his grandkids and eating an occasional pizza. There are thousands and thousands and thousands of Joes out there with urgent legal needs that involve their safety, housing, healthcare, and financial stability. The game changer for them is and should be ready access to civil legal aid. Thank you for your time. And Charlie Dingman is following me.
Thank you. He's on his way.
Good afternoon.
Charlie, there's quite a poor connection. We're not able to hear you.
And distinguished members of the committee. The internet is out here also.
Charlie, could you try turning off your video to see if we could hear you a little better, please?
Does that help?
That is perfect. Thank you. And we're sorry we can't
great.
see you, but we can hear you fine.
That's just fine. The internet is out here also, so I'm using my cell phone signal. Thank you for the time that you have taken as a committee to listen to the providers and to Justice Mead this afternoon. My name is Charlie Dingman, and I chair the Justice Action Group Legislative Committee, which consists of a few folks with legislative experience and a whole bunch of wonderful providers who guide what we are trying to do to improve access to justice through seeking your help in the legislature with the funding that has been desperately needed for decades. And when I refer to that, I'm referring to the longstanding view of Maine's judges and lawyers that it is essential to our system of justice to have access to justice for everyone who is confronted with serious legal problems, such as the civil legal aid providers confront every day. I want to talk a little bit about the Justice Index because that measure of the adequacy of a system of justice to provide justice for all forms the basis for the request that we have made of the legislature for general fund support for civil legal aid. The Justice Index, which was developed and is maintained by legal scholars who are passionate about our system of justice and equal access to it, has set a standard for low-income civil legal aid of 10 civil legal aid lawyers per 10,000 low-income people. That 10 per 10,000 standard is one that we would hope to reach in the next 10 years. Currently, Maine's Justice Index number stands at 1.6 to 1.8 civil legal aid lawyers per 10,000, less than a fifth of the standard that has been set by the index. It's also important to recognize that that index number, 10 per 10,000, is vastly smaller than the availability of lawyers to the general public. If you look at the whole population instead of at low-income persons, you find 40 lawyers per 10,000 people. So the 10 per 10,000 is not seeking a luxurious or extraordinary standard. It's seeking a bare minimum that would allow everyone who has a serious legal problem and can't afford a lawyer to have one. To get there, Maine's civil legal aid providers estimate would cost in the neighborhood of $70 million in current dollars. The goal that we set in asking the legislature for help was to try to get there in 10 years. That would mean adding $7 million each year. And LD 1326, which this committee favorably reported out to the legislature and which is resting comfortably on the appropriations table at this time, proposed $8.3 million in the first year of the biennium, recognizing a $1.3 million extraordinary need due to the pandemic, and then $14 million in the second year to begin that progress towards the Justice Index number. So that's the origin of the request. And the request, as I mentioned, is in its entirety still pending before the Appropriations Committee. And we hope that this committee will continue to attach a high priority to the passage of LD 1326 to the extent that the Appropriations Committee seeks your input on that subject. We are very pleased that this year, for the first time, the governor has proposed to provide some funding for civil legal aid in her supplemental budget. Part JJ of the supplemental budget that has recently reached the legislature contains a one-time appropriation of $1.3 million to address the pandemic impacts on both the need for civil legal aid and the funding of civil legal aid. The need has gone up and the resources have gone down as a result of the pandemic. And so it is tremendously welcome that the governor has recognized that need and made some provision for it in the supplemental budget. The problem with one time is the capacity needed to holding the number of lawyers available to meet the needs of low-income people with serious civil legal aid problems. That requires ongoing funding that providers can count on so they can hire additional lawyers and organize their work so as to reach more individuals. I want to note that there's a 2016 study which indicates that of those who requested legal aid in the low-income population in our state, about 34% had their needs met by the civil legal aid providers. As Justice Mead has said, the providers are very efficient. They avoid duplication. They are imaginative in the ways they use their limited resources and still could only reach a third of those who asked for help. And that number is no doubt significantly smaller than the number who need help. So this is an urgent problem. It's a long-standing problem. And we believe this is a year when the legislature has a real opportunity to make a major step forward. And we ask again for your support for LD 1326. We thank the governor for making a step in that direction. And we ask the legislature to find a way to make ongoing support part of this budget. I would be happy to answer any questions, and I know that the providers who are still with us would also be happy to answer questions if the committee has some.
Thank you very much, Charlie Dingman. And I would ask the representatives from legal services organizations, I think you're all still on the panel, but with your video off, if you are able to activate your video, then we'll be able to ask you specific questions. And I believe that Chet Randall and Charlie Dingman are available by phone to answer questions as well. They're part of this meeting. And so I guess before moving on to questions, I wanted to thank each one of you. That those were really terrific and moving presentations of the work you do. Thank you for sharing it with us, and thank you for doing the work. And there are lots of questions, so we'll begin with Representative Rackett.
Thank you. I wanted to particularly say hello to Liz Stout and thank her for taking over VLP from my dear friend Juliet Holmes Smith. We've had so many losses in the community. It's just been terrible. But it's nice to see you again, Liz. We worked together years and years ago, and I'm happy to see you in the post. So I have the question I have for you, though, however, is how is has VLP recovered itself and gotten reorganized and moving forward? It sounds like it has. Are you fully staffed and operational at this point?
Yes, we are operational, and we were able to do some fundraising to add one half-time staff position starting last fall. But we have moved all of our programs, which the large majority of them were where lawyers met face-to-face with clients. We've moved those all to remote operation so that people connect with lawyers through Zoom or telephone. That's allowed us to provide more specialized help for things like employment law, as well as protection from abuse matters all over the state, as opposed to programs that were previously just for walk-in purposes in Portland.
Do you think that, if I could just quickly ask the other end of that question, Is it your belief that the whole build out of broadband is going to help make that a particularly stable capacity in both your shop and others you've interacted with?
I do think it will be a great advantage for people as we look at returning to post-pandemic activities. We are looking at keeping some of our remote activities in place, particularly, as I said, for those specialized areas of law. And if people have access to broadband, that's going to make it a lot easier for them to access those legal services. So yes, we're very excited about that.
Thank you both. Representative Harnett?
Thank you, Madam Chair. Thank you, Justice Mead, Charlie Dingman, and all of the providers for being here today. Long time ago, probably 20 years ago, I had the honor of serving on the JAG when I was with the then Maine Bar Foundation. And it's somewhat ironic. It's wonderful to hear about the progress, but so many of the numbers and challenges are the same in terms of the inability to serve the entire state of Maine, and that saddens me a great deal. My question, and it's for no one in particular, but Maine is a pretty geographically diverse state. We have some urban areas, we have lots of rural areas, we have areas with very few services, and I'm wondering, how do the providers address the challenges of serving everyone in the state of Maine, regardless of where they reside?
I could take a quick shot at a little bit of an answer and then tag off with colleagues, but at least at Legal Services for the Elderly, we are heavily reliant on our local partners. So even if we have a presence in a part of the state, we want to partner closely with the area agencies on aging, the community action programs, and others. The people that come in contact with the people who need our help, basically. So we want to have a multiplier effect by having really close connections all across the state. And then we also, just as a matter of principle, are very committed to making sure that as far as whatever somebody gets from LSE, it doesn't matter what town or county they're in. We're rationing our services, so to speak, the same for everyone. And so we really are committed to making sure that there's equity there. So.
Thank you.
Maybe just to add to that too, I'd echo the points that Jay just made. And I know that a number of us also have, statewide helpline and are hearing daily from people all over the state and are serving people in all 16 counties.
Thank you.
Representative Babbage?
Madam Chair, I think Representative Harnett, first of all, I want to commend everybody for their service and dedication. And I feel fortunate to be looking at the faces before me and the charge that you all have and have dedicated yourself to. Following on Representative Harnett's question, my concern was assessing need and I don't know if I'd call it the referral process, but how people become aware of the service. Some groups may have advocates that provide a path. I suppose the fact that you're only meeting a portion of the need keeps you busy enough. But I was just wondering about how we might know what populations are being served and what might not be being served as well, with regard to knowing about the services available to them. I haven't got that directed to anyone particular, but I'd be interested in hearing a response.
I would just say briefly, Representative Babbage, that to echo what Jay and Robin mentioned, which is that we form close partnerships with a lot of different agencies around the state. And those ongoing relationships include conversations where we hear from them what their client base needs and we work together to address those needs. So getting the word out with our partners is a really important outreach. We also outreach directly with the court, and the court clerks provide information to people coming to court to try to find, to ask for solutions. So those are a couple of examples.
Well, thank you. I wondered if judicial officers were involved, but also then knowledge, the ability of people to know about these resources like area agencies on aging and so forth are essential for you to get the access to those folks. Thank you very much for all of your work.
Committee members, are there additional questions? I have one that's somewhat related to all of the questions you just heard, and it's really about statewide services. And I'm wondering, I know that Pine Tree Legal and Nan Heald in particular worked really hard on building a comprehensive website that provided information and self-help materials. And I was wondering if members of the panel wanted to comment on using web-based resources to help expand access to justice as well.
LSE has an online elder rights handbook. So we definitely see a high value in providing resources that way. It helps not just the people that will become our clients, but their family members and the private bar and our partners as well. So we do maintain that online handbook.
Yeah, at ILAP as well, we found online resources can be really valuable, both for the statewide reach, and we've actually really been able to expand this as well during COVID, realizing that we need to use our online reach to even reach people who are close by, but also with the large groups of individuals we can't serve. I mean, certainly the materials we provide are absolutely no substitute for having an attorney, but we're able to at least get accurate information out, particularly with asylum seekers. We have, like hundreds of asylum seekers now who are without attorneys, and we're doing the best we can to provide representation and to recruit pro bono attorneys to represent them. But we've also developed a really robust website resource for people who are in the immigration court process and who don't have attorneys, just at least explaining what the process is and, giving them some tips on things to watch out for. So I think that is really important.
And just to chime in with one last piece there, I think, just to say that I think that has become even more important, like keeping materials and information and resources up to date, even more important and time consuming during the pandemic as policies have changed, resources have shifted, what people can access in terms of supports has just changed a lot. And so keeping that up to date and getting that information out to people has been just really important. And we've, done everything we can to do that so that folks can access the supports that are available to them to meet their basic needs.
The providers' websites are absolutely terrific. And I'll just take a moment to highlight the Pine Trees. Pine Tree has been recognized nationally. They were a leader across the country in innovative use of the websites. Their website is worth a visit if you haven't seen it. It has fillable forms. It has basically artificial intelligence where you can have a conversation with a robot who can direct you to the services that you need. It's just absolutely terrific. And as was mentioned previously, our providers collaborate and cooperate. And if someone reaches their particular website and it's not really the provider they need, they can easily be shifted off to where it's supposed to go. But I just want to give a shout out to Pine Tree. They have kind of led the country on online services. Of course, that all depends on whether or not the people seeking the services have access to the internet. And the other problem is if they just type in legal assistance, they get a barrage of attorney advertisements, which kind of is not what they need. It's not going to be a successful one, but the ones that reach the appropriate websites are terrific. And as mentioned earlier, our clerk's offices, when people come in, we get requests for legal help and legal advice all the time at the clerk's offices. And of course, they can't give legal advice or help, but they know where they can send these people for the appropriate needs they have. So the challenge is to reach the people who need the help. And it's hard to tell how effective that is, but I'm satisfied that everything possible is being done to get these connections to the resources that are necessary.
Senator Carney, this is Chet Randall. Can you hear me now?
We can. Go ahead.
Great. Thank you for those comments, Justice Mead. And in addition to the comments made by others, I would just also add that in addition to our website, Pine Tree Legal Assistance or PTLA.org, we also maintain a website for veterans specifically. Our stateside website is also a national website. It curates articles and materials and content contributed by experts around the country. And that's another way that we've been able to try to reach veterans in particular in Maine and elsewhere to provide assistance. I'll also note that we had, like the others, we have many collaborations. We have a project at Togus, the main campus for the Veterans Administration's health services, where we run a clinic. We have medical legal partnerships in health clinics and communities in different places, including Penobscot County, Lewiston, and up in Washington County. We strong ties and collaborations with the community action programs in many of the local communities. And so there's a number of different ways that we try to leverage our ability to communicate with and reach the client community that needs our services and the services of other legal providers on this webinar in order to provide a robust referral service when appropriate and needed. So both the web presence, and then I'll also just mention, I think we all are trying and looking at ways of leveraging social media and ensuring that folks who have access to maybe a cell phone but not a computer are going to be able to see announcements and changes related to their living situation that might impact or improve their circumstances. So I'm thinking of things like Facebook and WhatsApp, which is a texting tool, and other things like that that allow us to enhance access to services and information, as well as making connections to us. And then lastly, I'll just point out, all of us are working on trying to do online intake systems that would allow us for, at least Pine Tree is, intake systems that allow folks to try to get their requests for services to us in a different tool or mechanism that they may not otherwise have used. I'm happy to answer any questions about those things specifically.
Thank you. I see that we have one more committee question from Representative Evangelos. Go ahead, Representative.
Thank you, Senator Carney. And Justice Mead, thank you very much. Very efficient docket you presented today. It's 2 o'clock, so well done. Which leads me just a really quick question. Is the docket still in crisis in terms of the numbers?
Yes, yeah, it's the same problems that we have with the dockets. As you may know, in May of 2021, we started a couple of initiatives we called post-pandemic planning. We thought the pandemic was going to be post by the summer of 2021. It isn't. We're searching for techniques and efficiencies, ways to kind of whittle it down. We haven't found the magic bullet. I mean, one of the things we're doing right now is there's big backlogs on the civil side because they're low on the priority list. And almost all of the Supreme Court justices, my colleagues, have volunteered to conduct judicial settlement conferences. So now judicial settlement conferences take up probably 20-25% of my week, where we meet with folks who have big cases pending that tend to stop up the docket. We meet with them and try and offer our perspectives and our urging to find a way to settle the cases, and it's actually been quite successful. That's a drop in the bucket. There's, I think, 4 or 5 of us doing it, but we're trying to find every little way to move the cases along. We have enlisted fully retired judges who are fully retired to sort of come back to work as referees. The case will be referred at them for refereeing, which basically it's the equivalent of private dispute resolution, arbitration. So I'm taking a long time to answer a simple question. The dockets are still backlogged. All of our providers' dockets are backlogged. All of our criminal defense attorneys have enormous backlogs in their offices too. No one's found the magic bullet yet.
Thank you, and thank you for your work. That's all I got, Madam Chair. Thank you.
Thank you. And just again, a heartfelt thanks on behalf of the entire committee for your presentation today and also for the work that you've been doing to help Mainers across our state find access to justice for their civil legal needs. We really appreciate the work you're doing.
Thank you so much on behalf of all the providers.
I think at this point we'll say goodbye, and I'm going to move you into the attendee part of the meeting, or you can simply just exit the meeting. Thank you. Let's see. All right, committee members, I think we are now back to just members of the committee on the panel, and we are going to move into the next portion of our agenda for the afternoon. And that is a work session on MCILS issues. And I'm just going to take a moment to see if Justin Andrus is here. Hi, Peggy.
Hi.
And he is. I'm going to bring him over to the panel. I think that worked.
All right.
Hi, Justin Andrus. Welcome back to the Judiciary Committee.
Thank you.
It's nice to see you this afternoon.
Thank you for having me.
We don't have a terribly structured agenda for our time with you. I don't know if you have a particular place where you would like to start. I think what the committee would be interested in is hearing what the priorities are from the commission perspective, and then also what the priorities are from your perspective as the executive director.
Okay, so some of you may know this, but for those of you who do not know this, we were sued by 5 defendants with the support of the ACLU this morning. So the threatened lawsuit that we've talked about off and on since I first began appearing with you is here. And so if I'm a little bleary-eyed or a little less polished than I sometimes have, it's been a day of talking to reporters and other stakeholders about what that's all about. So I'm going to ask for your forgiveness about that. I don't know how not to sound fresh to say the priority has to be to continue the transition and succeed in the transition the rest of the way. I have 4 discrete things that we'd like to talk about, happy to talk about. Reasonable, discrete bites at some changes, relatively controlled costs and stuff like that. And that's what I thought I would bring to you today to see whether there was any interest in doing these things. But our work at MCILS and the work of the legislature, I think ultimately has just been a little bit complicated and a little bit, not that what we do today is outside of our control, but the path from here is a great deal less under our control than than I perceived it to be, really. And so,
Justin, can I just ask you a question? 2 questions, actually. First of all, I know that you have had a very busy day. Do you need a couple of minutes to just kind of catch your breath? Because we could take a little break if I don't know what you were doing immediately before 2 o'clock.
No, this is the caught breath version. If you all need a break, I am happy to stand by, sip my water, continue to breathe deeply. But
no, I think we're okay. I just wanted to be sensitive to where you are.
No, I appreciate that. The awkwardness is in the nature of our professional relationships here, and in trying to think about how to proceed from this point in a direction that makes progress, that we can work on, that isn't going to be undone by some court decree. I don't think it's wasteful to continue to make progress. I think it's important to continue to make progress, but I also, where before I would have shared with you a master plan, and I don't know whether any of you have seen it, but in our commission packet this week, there's this long outline of all the kind of stuff that we're thinking about. It's not, details aren't cast in stone, but we had this master plan, and now the terrain has shifted pretty radically. So that's the uncertainty comes from that place of uncertainty. Normally, I know it's not my meeting to moderate, so forgive me, but I guess I would like to pause, and if anybody has questions about the suit, I don't want to get into like defending allegations, but what the allegations are in broad terms or what our perspective is, I'm happy to share that. I don't need to do that unless that's of interest to members of the committee.
I think it's probably of interest to all of us, but I think it would be better if you could send us a copy of the complaint, and then maybe we can schedule a different time for that conversation. I also know that you are working very hard in your leadership role for MCILS to improve the organization, and I think we would be interested in hearing your plan going forward, because it's important to us as legislators to understand what what we can do from a legislative perspective to support the organization. And so if you could kind of proceed with your plans going forward, I think that would be really helpful to us.
Sure.
And how we can help you meet those priorities.
So in overarching terms, the initiatives that we came with last year remain in place as the will of the commission, and I support them as the executive director. They include continuing on a path to achieve parity with the prosecution function in terms of staffing and resourcing. And they include continuing on a path toward using a hybrid of the assigned bar and paid public defenders to support indigent defense. We have lots of people doing lots of good work. We still have the issue of decreasing population in the bar, both from attrition and from people opting out. We have staffed all of our cases. A year ago, I was really worried that we were crashing out to a place we weren't going to do that. We haven't done it, made it. But there are still places where the loss of specific individuals could become problematic. And so I hope that we will continue toward a place where the defense bar has access to the same opportunities the prosecution bar has, and that we're serving the clients through that sort of a hybrid model. And that's not news. That's the same as before, but that all persists. I know it's really fraught to talk about what reimbursement rates and things are. I have a memorandum I'm putting on my list to send you if you haven't seen it. That lays out really what is available to a prosecutor and what that costs to achieve for a defense attorney. And it gets really difficult to talk about because of the perception that the defense payment rate is like a salary or is like a wage, but it's really not. I know we've talked about this before, but that could be a useful document because we've really done some numbers, really looked at what that means. We surveyed our bar. We got numerically reasonable sample of responses, and we've looked at what it really looks like for them, what they're spending on health insurance, how many don't have health insurance, what they're spending on health insurance, that they're catastrophic policies, because they're catastrophic policies and that's all that they can afford. They don't use the policies, they come to work sick. That's not good for them, but that's also not good for clients. People don't take time off when they should. It gets into all sorts of stuff like that, loan forgiveness and everything else, and what the consequences of all of that are. And so last year when we talked about it, all I could say was we need them to be paid better. I will send you that memorandum and you'll be able to see why. Somebody asked me earlier, a journalist asked me earlier what that rate should be. And it really depends on how we resource them. So anything that needs to flow through the attorney needs to be included in the rate. And that's not really the payment rate, that's the service rate, so to speak. But if we provided them a service directly, then it doesn't have to be in the rate. And so there may be ways to deal with that. So that's element number one. Element number two, the Kennebec Public Defender Office that as I
Actually,
understand.
Justin Andrews, I just wanted to interrupt you for a second, because as you're going through the elements, I'm wondering if you would like to have questions on each element as
Absolutely.
you complete the discussion. I think it'll make our conversation flow a little better. Thank you. Committee members, are there questions on that first element of Justin Andrus's presentation? Representative Harnett, go ahead.
Thank you, Madam Chair. Thank you, Justin, for being here today. I imagine it's not the day you anticipated when you woke up this morning. And, you know, we do talk a lot about money and reimbursement rates, and we heard a lot about that when we listened to the private attorneys who provide this constitutionally required service late last year. We were able to move from $60 to $80, which was helpful, but not enough. And I was surprised today to read in one of the articles covering the lawsuit that the federal reimbursement rate is $158. I know our goal, and as was stated by the commission, was to get up to $100 to try to achieve some parity. Is that the right number?
No. Parity for defense attorney who is, and I'm not multitasking you, I'm working on getting a document in front of me so I can give you hard numbers. Parity for defense attorney with a prosecutor, assuming a $70,000 a year salary, which makes them a middle of the road prosecutor, not the most highly paid prosecutor, is $150 an hour. Again, that number could vary depending upon how they're resourced. That's assuming they're paying for all their own stuff. So in the memorandum that I'll send you, it lays out, for example, what a paralegal costs with state benefits and things like that. And you got to remember, when we're talking about state personnel costs, the benefits have a huge economy of scale. The numbers are actually probably low because not having access to the state healthcare plan means that healthcare is more expensive to insure an individual. But even putting that aside for the moment, you're over $100 an hour by the time you've paid the attorney $70,000 a year and an equivalent benefit package to a state employee. And then given that person a single staff person, and I use our paralegal rate at about $41,000 a year to, as that staff person for purposes of the calculation, right there, you're over $100 an hour. You still haven't dealt with office space or any of the expenses associated with it, utilities, internet, phones, insurances, and that stuff's in the memo. I won't catalog it all here, but you haven't dealt with any of that. And then there are the sort of additional problems of trying to figure out how do you account for the intangible benefit of the loan forgiveness program that you could get as a prosecutor, but under federal law, you can't get as a contractor. And so even at $150 an hour, you haven't actually achieved parity. And I hear myself, I understand that it's very simple for somebody to say 150 times 40 times 50 to get to a reasonable annual rate's $300,000 a year. That's too much money to pay the lawyers. But that lawyer is really taking home gross pre-tax pay of about $70,000 a year at that rate. That's how expensive the benefits are. That's how expensive the stuff associated with operating a law firm is. So does that answer your question?
It does. A quick follow-up, Senator Carney. And I don't want the focus to be just about money because we have lots of issues to deal with. But you mentioned the decrease in the number of attorneys accepting cases. I guess my question is, did the increase to $80 stem that tide or turn that tide in a different direction? Was that a appreciable increase of the number of attorneys, or was it did it not really have more people sign up to be rostered attorneys, result in more people?
Really, really helped, no question. And I don't want to suggest otherwise. I keep silencing my phone because it keeps being journalists keep calling it. Sorry. Peggy, I'm sorry, not Peggy. Senator Carney.
Yes.
Can I take you up on that minute to step aside and just take a breath?
Yes, please do. And we can reschedule too. It sounds like you have a lot of people reaching out to you. So let's take let's recess until 2:30. And then if we come back at 2:30 and you would like to reschedule, we can certainly do that. Okay.
I'll be ready to go. Thank you for that.
See you all at 2:30. Committee members, let's take this opportunity to take a break for the rest so that we can be ready to complete our work this afternoon. Thanks. Hi, committee members. Welcome back. Representative Harnett, your hand is raised. Did you wish to be recognized? Or is it residual?
Yeah, I'm not sure what it is, but I did not wish to be recognized. Sorry about that.
That's okay. All right, I think we're ready to resume. Give me just a moment here. Justin, I deactivated your video once you stepped away. I am a little concerned that it may be better for you to spend time handling your interoffice communications, and perhaps it would make more sense for us to reschedule. I did note that you sent us the information that we had requested, the complaint and some other information. How would you like to proceed?
If it's okay with you, I would appreciate the opportunity to share some information today. I had a snack, took a few steps, and I should learn that an offer of a break is like a mint, never turn it down. But I'm ready to go. Okay.
Great, thank you. We appreciate that. And I think where we left off was that you had spoken to us about parity between prosecutors and members of the MCILS defense panel, and we were taking some committee questions on that topic.
So there was an outstanding question about the effect the pay change had. And if I may, I would like to answer that.
Please do. Thank you.
So the increase in pay absolutely had a really good and positive effect on attrition. We had an exodus prior to that for a variety of reasons, but one of the major ones was the rate of pay, and that exodus decreased. In fact, in August, we were down to 225 people accepting new cases. There were additional people in the system who had cases, but had said, please don't give me more. And we're up to 279 or 280 typically on any given day. That 279 or 80 is not always the same people. There are perhaps 300, 310 people who have cases, and they come in and out to manage their caseload. And so that part is working much better. And the threat I saw in August of sort of an immediate failure of the ability to staff cases seems to have been stemmed. We do continue to lose people. And so although that number of people taking cases has held steady for a while, people are finishing their cases and not coming back. And that's still happening. There are a few reasons. As always, one of them is as I've changed our protocols, there are folks who don't want to participate in that, and I acknowledge and respect that. Part of it is people are aging out, and you'll see in a memorandum I sent you over what we stopped. I'm not going to read all of the numbers, but our average MCILS attorney is 52 and has been with us for 9 years, which means that many of our people have been from the beginning, and we are not having a replacement rate that is going to be sustainable. I can't tell you when that becomes a problem, but we can see that problem evolving. And again, without reading you too many numbers, there are quite a few counties, Hancock, Lincoln, Oxford, where the average age is over 60. Not that a 60-year-old can't practice very effectively. We appreciate those folks, but we're not getting the 32-year-olds into the system in those counties, if that's where the averages look like. So I'll stop with the numbers for a moment, but that's concerning to me. So one of my goals is, as we make it more financially reasonable for people to do the work and to be supported, feeling like they're doing the work on an even playing field with the state, in terms of investigators and health insurance. And, one of the criticisms we get is they don't get paid for trainings. They don't get paid to go to meetings, while prosecutors are salaried, so they effectively do. We also need to be building routes to entry. And one of the specific things I'll talk about in a minute is an idea for trialing one of the ways we might do that. So that's all an answer to the question, what was the effect of the rate change? It was very positive, but that we do continue to lose people, both because it's not a good business proposition or a good lifestyle professionally, and because we're just graying, the graying of the bar generally is a problem, and particularly for us.
Thank you for that response, Justin.
Representative Evangelos, go ahead with your question.
Thank you, Madam Chair. Just wanted to comment about a couple of things. I don't know, the money helped a little bit, but we did go from 420 to 220. Now we're back to 279. So $80 didn't do it with inflation and lack of paralegal pay. We've had this discussion before. I'm not going to repeat it all, but I do want to talk about something briefly. While it's true that the agency who received the lawsuit is your agency, Justin, this is not your problem. It's the failure of succeeding legislatures and chief executives to provide the resources that are necessary to guarantee adequate Sixth Amendment protections from our criminal defendants. It's our failure, and it's the chief executive's failure. We're not putting the money in the budget to fix this. And now that we've quantified the problems so well with the forum that you held, I'm hoping, and this is to my chairs, we are going to be bringing some bills forward, aren't we? To fix this, right? I mean, we've talked about it all year. Are we going to be developing legislation to address better pay and benefits and paralegal costs? Where do we stand on that?
I think that's one of the purposes of this meeting today, is to hear from the executive director what his priorities and suggestions are on both his and then also the commissions as a whole, to the extent that they might be different, they might be the same, but that's what we're here to hear about today.
Okay, but if we've got to vote all our bills out by mid-March or something, we're going to have to develop a proposal pretty soon and hold a public hearing. I mean, the worst thing we can do right now, lawsuit or no lawsuit, is we've had people like Justice Alexander, Mr. Cummins, and the other good contributions we're getting from the commission. We've got to move, go big or go home, right? I mean, this is the time. I mean, baby steps aren't going to fix this. The lawsuit proves it. I feel like they're the agency who got the lawsuit, but we're the problem. Us meaning collectively, myself included, our inability to pass legislation that'll remedy these deficiencies, and the inability of chief executives to get behind us. We've got, I guess, 10 or 15 days to get that changed. So I'm on board. Bring some big proposals forward, Justin, and I'll support them.
Thank you.
Representative Moriarty, go ahead with your question.
Thank you, Madam Chair. Just following up with the previous question, is there anything on the AFA table at this point that pertains to hourly rates or other support for the commission?
I believe the only thing on the table today is the Kennebec Public Defender Office. My recollection is, and I'm still learning my way through all of the legislative side of this process, but my recollection is the bill was paired of the other forms of public defense office, and then that office went through, I think it went through to have been implemented in January, not in its original form. The idea being there would be time to spin up the internal staff and then spin up that office. But I believe that is the only thing still on the table.
Thanks.
And just to provide some clarification for those who may be listening, the Kennebec Public Defender Office is a geographically limited pilot. So it's not a pilot project in the sense that it's limited in time duration, but the proposal is to establish a public defender office that kind of has its focus on Kennebec County and to initiate the program at that level. Did Representative Harnett, your hand is raised. Is that with another question?
This is a real hand. Thank you.
Okay,
Madam
great.
Chair. And I think that Justin painted the picture accurately about what's on the table, what's not. I just want to get confirmation from our analysts that's where things stand, Peggy?
That's my understanding. It's LD 1686, and it's on the appropriations table. That is an act to implement a geographically limited public defender office.
So we do not have a $100 rate on the table. That
You do not.
we do not. Okay, thank you. I'll get that hand down.
Justin, I think you were speaking to us of your updates and priorities. Did you want to move on to the next topic, and then we'll take a round of questions?
Yes, thank you. So as I thought about how to have this conversation, I tried to branch off some discrete things that I thought would make significant improvements, short of a wholesale overhaul that we very much need. And so by turning to this, I don't want to abandon that. It's just a internal subject. I think you've all heard me talk about the concept of a flying squad. And so that's one of them. The idea is to have paid defenders who we can dispatch effectively. I want to make clear that this is a Band-Aid a little bit, but it has a couple of pluses and a couple of minuses. One of the pluses is that it gives us operational flexibility so that if we do lose the one or two attorneys in the places I mentioned earlier, we don't lose the ability to staff cases. These would be people who would go to somewhere, Washington County comes to mind right now as a place we're in need, and could meet with their clients there. The clients wouldn't have to travel to Bangor or Brunswick to meet with somebody. And ideally, the court would schedule them so they were block scheduled. So they go up for a few days and get a lot of work done in a relatively short window. I've already started talking with the judicial branch about that. They're interested in that. We haven't reached terms, but they're supportive of that idea. As an aside, one of the things the judicial branch tells me is part of the conflict for them in figuring out how to move forward with the backlog comes from trying to move cases, but then having attorneys, both defense and prosecutors or AGs, cross-scheduled and trying to work that out. So this block scheduling is a way to try and eliminate that issue to some extent. My idea is that there would be 5 of these people. I would send them in sets of 2 to the outlying places, in part because there may be conflicts. And when there's not conflicts, it would enable them potentially to go to where the clients are. I don't want to send an individual into the field, but pairs of people is safer for lots of reasons. And so the idea is that there'd be somebody in the office and 2 sets of 2 in the field, and those sets could be changed from time to time. It doesn't always have to be the same configuration.
Can I interrupt you with a question?
Mm-hmm.
Could you comment a little bit on, you had mentioned earlier the concern that attorneys are simply, I think you used the phrase, aging out.
Mm-hmm.
And also now you're bringing up the subject of there are certain prosecutorial districts in Maine that just lack the available attorneys to do this criminal defense work. Can you talk a little bit about those 2 interrelated problems and the impact that those 2 problems are having on your ability, the organization's ability to provide legal defense?
Sure. And I want to pause because the litigator in me says, here come all of the admissions that they need for the lawsuit. But this is the truth. This is the reality that we're faced here at MCILS.
Yeah, if you don't feel comfortable answering the question, please don't.
No, I do. And I want you to hear this stuff. And, someday I'm deposed, I'll say the same things. So we have counties where we don't have very many people. Washington County, I keep referencing, I used to talk about Aroostook primarily. Washington became a bigger issue. On one day in December, I was asked for data about available counsel in Washington County. We had a few people on the list there to accept cases, but we didn't have anyone in Washington County that day accepting cases. So we're able to assign counsel, but we're in a position where that counsel is not located closely to the clients, and the clients have to either travel or rely on the telephone to talk to counsel, and that becomes really problematic. In addition to that, if we start to lose people because of the aging out or for other reasons, then our ability to staff up there is imperiled. This is a matter of public record. You may have seen this, but one of our rostered attorneys was subject to an immediate bar suspension a week or so ago. And that's a person that had been taking cases up there, and now that's a person who's not, and the number is further depleted. And so we haven't yet reached a point where I can't ship somebody from far away to do a case. But as great as the lawyer may be, as well as that person may provide services, the experience for the client, if they can't go to where the lawyer is, meet with the lawyer at reasonable expense for transportation, at reasonable convenience, then that impairs the attorney-client relationship at no fault of the lawyers or the clients. And so it's already the case that we've eliminated the geographical restrictions on people going to remote counties. We used to try and keep people kind of close. As I understood it, it was originally a cost issue. We didn't want to pay for too much driving, which is reasonable. But we had to eliminate that in order to be able to staff cases in Aroostook County and Washington County and Piscataquis County at times, Oxford County for child protective cases at times. It's come almost everywhere. And so when we look at the table of ages, it's really problematic. And, you know, we're really going to start to see that graying out as people take a step back. This week, when people in the world are having real struggles, it's hard to really talk about lawyer work being difficult, but it is genuinely difficult. And people get tired of doing it. And when we look at the ages, Andrew Scoggins, 58, Hancock, 62, Knox, 62, Lincoln, 63. When we start to see people getting to the point of retirement or withdrawing from practice, we're really at risk that without an entry program and or the ability to dispatch employees, my first choice is that they actually have an office there to begin with. But putting that aside for this part of the conversation, I think we're really, there's a real threat that a day will come we're going to have a hard time staffing a case.
Can I just also ask you, do you think that 5 is the right number for this kind of dispatchable unit within MCILS?
I do, for a few reasons. So ultimately, 5 employed attorneys is probably not enough unless they're located precisely in one place. The reason I picked 5 is I want teams of 2. They can work separately if there's a conflict issue. They can work together for safety when there's not a conflict issue. It is foreseeable that I'm going to need them in 2 different places at the same time. So I get to 4. And the reason I picked 5 and not 4 when I was thinking about it is it makes sense to me that there's somebody in that unit who's at their desk with all of the infrastructure resources. We've all learned to work remotely, but I'm not as effective with a small laptop at my kitchen table as I am at my desk here with big monitors and real printers and all of that kind of stuff. So that's how I got to 5. Is it worth trying with some other number? Sure. But that's how I arrived at that recommendation. I don't know what the interest is. Go ahead. I'm sorry.
Yeah, no, I wanted to open it up to committee members if they had any questions about this, the suggestion of the group of 5, but I appreciate that I may have interrupted your completing your description of it.
Just one more paragraph. I don't know how many people really want the job of paratrooper in the law. When I was a young lawyer and before I was married and had a family, I would have loved that. I like road trips. I like going different places. I like eating in diners and meeting people. Somebody that's going to appeal to. But I don't know in the end of the day how successful the program is going to be. It seems like a good way to experiment with employed attorneys. The things they'll develop to make this program work would be useful for more if we ever got there, and not wasted if we didn't. And so, but there is certainly the possibility that there aren't 5 people to whom it's appealing to potentially be dispatched.
Thank you. And I see that Representative Moriarty has a question. Go ahead, Representative.
Thank you, Madam Chair. Mr. Andrus, I'm intrigued by your idea of the flying squad, but Representative Evangelos was right on point, and that is that in a week and a half, we have to, that is our target for the reporting out of all bills. Are you in a position right now where you actually have draft legislation, or is this just a concept with which the commission is dealing right now, but is not yet ready to move forward?
I have numbers and memoranda language that I could turn into proposed legislative language tomorrow. So we've made some assumptions. Let me back up a step as we have this conversation. We have developed caseload standards, assigned point values to different cases for how much time they take, and figured out, based on ABA standards and looking to Massachusetts and how long cases take here, how many points of worth of cases people should do. And we've actually developed the ability since the last time we had this conversation to really look at how many people we need in a specific place to do the job. In addition to that, we've costed out for every kind of player who would be in the public defense system, what they cost, both for salary and startup costs. And so that's allowed us to say, okay, I can tell you exactly what these defenders cost for salary and benefits and their associated costs, bar dues, computers, desks, all of that. The only thing that's a little intangible is the costs of travel and accommodations, because we don't yet know exactly what that's going to look like. I had to make an assumption there, but I could have a bill for you. Well, what I call a bill, I could have Representative Harnett knows what I think a bill looks like before it gets turned into a real bill, but I could have that for you tomorrow.
Yeah, well, that's impressive. That really is. But let me ask you this, if I may do a follow-up. Knowing what the road will bear, and given the time frame, would we be better off in focusing on yet another attempt at a rate increase generally, as opposed to the creation of the flying squad?
Can I add to that question a third option, which is a statewide public defender office? Can you comment on each of those 3? Sorry to jump on your question, Representative, but it seemed like.
In some ways, it asks me to choose among my children. And so I believe the first goal, first principle must be parity. And that means a rate increase or funding things that don't have a rate increase, but are providing insurance and things like that directly to lawyers. And I'm sorry I didn't think to send it earlier, but you'll be able to see after the meeting. I have sent that memorandum to Peggy. And so from that flowed all of the other things. So that cost could be applied equally to an employee or to a contractor. And so, and that could be applied equally in one place or statewide. Those principles hold universally, which is why we did the math I was describing. And I just want to give credit to Deputy Director Maciag, who's really responsible for pulling a lot of those numbers together. But I think a statewide public defender's office always involves, at least as it's going to exist in Maine, as I could see it, always involves being a hybrid. They're always going to be assigned counsel, even if there is a statewide brick and mortar public defense office. My view, we should have a statewide public defense system, brick and mortar, every county. And I can tell you in this conversation, if you tolerate me clicking, how many employees you need in any given county to do any proportion of the caseload in that county. And from that, I can tell you what that will cost for each and every county. And so, or I could take some feedback and reconvene with it for it or send you a document. But a statewide public defense system, I think still looks like a hybrid system, Senator Carney, to address your question directly. And Representative Moriarty, we need to finance the lawyers effectively. That's a first principle. It does help avoid the attrition and get people into the service. That probably is more immediately valuable than the flying squad, but certainly a bigger ask. And so I don't want to be a choosy beggar. Any of these things is going to help us go in these different directions.
Okay. Okay.
Senator Keim, go ahead with your question.
Thank you. Director Andrus, how much thought have you given to this other suggestion that you've sort of been discussing about providing insurance or other services to the lawyers that the rostered attorneys? How much information have you built around that suggestion, and what can you give us for figures on what that looks like, or the benefit you would see that in comparison to a statewide defender office, public defender office?
Some very precise detail on not every subject is really the short version. So for example, one of the things the lawyers have asked for is access to legal research software comparable to what the state gets. So the state has Westlaw Edge as its product that's available to it. And we have communicated with Westlaw to determine what that would cost. And it's a lot less than the last time we did it. A year ago, it was going to be about $220,000 a year. And yesterday, we got a number of quotes from them, would be about $60,000 a year. Now we would have to put that out for RFP. But if we did and they were the best bid, then that's great. And if somebody else is a better bid, it's even less. So all of a sudden, that's a really attainable number. To do that, I need a bill, and again, happy to do some drafting. I need a bill that authorizes me to pay for attorneys' stuff directly, because right now I can only pay attorneys for their reimbursement fees for doing the work, right? So I've got to build everything in under the existing statute. With that, and I don't have the number at the tip of my tongue, but prosecutors get copies of these books we call Vertico. If you hear somebody talk about that, that's the author who makes compendiums of the criminal laws and the motor vehicle laws, the Vertico books. They come out every year, and prosecutors get a Vertico. And we should provide people who do our work principally with a Vertico. But those costs are manageable. All of that is less than $100,000 a year. We have looked at the loan forgiveness issue. What we've learned is that it's a federal CFR issue, and there's a 0% chance that they're going to change that for MCILS. Contractors just aren't going to earn loan forgiveness. However, there are many states with loan payment plans for contracted assigned counsel. And those costs vary wildly depending upon what the benefit is. And so we could have a conversation about what does it cost? What does the state want to spend? We could have a program there that for people who were doing our work, over some proportion, they would get some contribution toward their student loans. I will tell you, when you see the data in the memorandum about people's student loans, it's horrifying. As you will imagine, the younger you are, the more student loans you have. And that's not just because people haven't had as long paying off the debt. That's because the debt's going up, or the cost is going up. And there's a remarkable number of people who are making either interest-only payments, not touching the principal, and even people who are not making, they have income graduated payments that result in them not even paying all the interest. So some interest is being capitalized every month, even while they make their payments. They're making payments and their debt's going up. And so that's a real barrier when you could work for 10 years at the prosecutor's office and get rid of it all. And that would just depend on where you all decided the intersection point was. My recollection is, I don't have the number in front of me, that it was about $3 million to pay it all. Certainly we don't need to pay for everybody, though. Not everybody's in it. I've had a harder time coming up with equivalent pension programs. And we don't want to be a pension program administrator here. So really it means finding an outside partner to administer retirement program. Similarly, it's very difficult to assess the risk pool, and I've been unsuccessful in finding out what a managed healthcare program plan would look like. Eventually probably we could tease that out, but we haven't been successful yet.
Okay, so to recap, what you've looked at is healthcare, pension, legal research material, loan payment plans, and something called Vertico. Those are the things you've looked at that would be services in addition to, that you think would be beneficial to offer assigned counsel in addition to their hourly rate, that would attract more people to work for MCILS.
I think that's right. It would be hard to figure out, for example, how to subsidize rent directly for people's offices. Although a solution could be, in some places at least, we could rent a place that they could office share where they can meet with clients and they don't have to be there to do their drafting. Utilities, we have the same problem, landline, telephone, all that kind of stuff. And I'm not multitasking, I'm looking at my list of things that we found for them. Legal malpractice insurance is another one where it's so specific to the risk the individual presents, it would be difficult. It appears the majority of our attorneys are bare as far as legal malpractice insurance goes. Now, it's hard to bring a legal malpractice claim in a criminal case, so that may not be an unsound business decision, but I'd certainly prefer that people have that benefit.
Okay, thank you for these ideas. I'm not sure. I guess I'm looking at everything that we're talking about and feeling like a little bit like we're diving too much into some of the weeds, and yet I'm not sure how we go about making changes. But I'm very eager to discuss this more and listen. So I'm sort of walking through it with all of you.
And I have a tendency. So we have all sorts of weeds here, and I have a tendency as we start to talk about something to really devolve. So you pull me back out, and I'll be happy to do that. The next big area, so let me just back up. There's the flying squad. There's providing research materials to the lawyers. The third thing is a training budget. So we have a $16,000 account. We call it the conference account, and it's $16,000 we've accumulated over the years that we can use to pay for costs associated with putting on a training. Those are not appropriated funds. Those are funds we collected from people who attended trainings. They don't replenish. So one of the things we absolutely have to be doing is putting on trainings for assigned counsel that don't cost them anything. We really should be we're paying them to attend the training for the time, but at least we got to get to not charging them tuition to attend the required training, and having space to do that in, and the ability, not all the time, but some of the time, to hire outside presenters. So there's a guy, for example, named Larry Posner, who's a brilliant cross-examiner and really good professor. We'd like to bring him in, but we can't afford to do that. The next initiative would be an appropriation and authority to spend money on training, both for infrastructure and food, and also for folks. I talked to a person who puts on big trainings, and she was paying about $25,000 for 2 days for space and lunch for people to do that. I'm assuming we're going to have a bigger turnout because we have a bigger bar, and some of the stuff will be required. So my estimate was to do 4 2-day trainings a year. It would cost us about $250,000 for the space and the food. That I would hope to have maybe $50,000 to pay these outside presenters to come in and teach. So that's the third initiative. And the final initiative, and this has the real potential to get in the weeds, so keep me up when I get too far. I pause because some of this here could feel like an end run around decisions the legislature made last session. And so I'm certainly willing to hear that, and that's not my intent. But there are things we need to do that we can't do with the people we have. And my thought was to issue contracts to have individuals who were specialists in certain areas. If they were working on a specific case, they would just bill through our case management system. That's nothing new. But when they're doing system level work, they can't bill that to a case. And to get them to do that work, we would need them to do some, have some contract. So an example of this we're already doing, we have a contract with a Portland lawyer who's an immigration specialist, and she has a contract with us to be available to answer immigration questions for any client. I propose 4 categories. One is a diversion and mitigation specialist who is dealing with helping divert cases out of the criminal justice system where appropriate. We should actually realize a cost savings for those, even though we'll be paying her on a contract. She would also help with mitigation at sentencing, which is a function we should be doing better than we are. The next one is somebody focused on appellate work. So would be a lawyer already doing a lot of appellate work. When this person did appellate cases, they would simply bill it as normal. But they would also be collecting case law nationwide as it evolves and putting up bulletins to the lawyers. Here's a change in search and seizure law. You need to know about it for your motions to suppress. Here's how you set up the issue at the trial level to preserve your appeal after the trial, that sort of stuff. The other 2 people are a little bit different. One would be an idea where we would have a contract with somebody who agreed to bring in a new lawyer. And that new lawyer would take our trainings and become MCILS qualified as soon as possible, but is going to need some direct supervision, mentorship, and oversight as they come up. And that activity is not billable to a client. So the idea was to provide some flexibility for a person to be willing to perform that service for us without having to take the hit of a significant amount of time that they were not able to bill for and thus didn't have any revenue for. And then finally, the 4th one would be somebody who, and any one of these, by the way, could be more than one person. If time could be split across multiple people, no real increase in cost necessarily, or multiple firms could bring people in. That would increase the cost, but we need to do it because of those, the aging out problem in particular. Similarly, this 4th person would be somebody who would be available to be co-counsel or participate directly in a case to help a lawyer acquire skills that the lawyer doesn't have yet. That would simply be billed to the case. But the person might also do some, direct monitoring or oversight of folks in the field. In thinking about this person, I'm thinking about the American Bar Association standard that suggests there should be no more than 10 attorneys to 1 supervisor, which suggests that we ought to have something like 30 supervisors out supervising these folks in the field. That's not our reality today, but this is a person who could have a hybrid role of sort of being present in the court from time to time to see what's going on and also being available as a direct resource. My idea was to cap the contract side of each of these at a rate similar to what our existing contract, the immigration person was, which is about $60,000 a year. And so for those 4, if there were 1 in each of the categories, those 4 contracts would cost about $240,000. I think I can probably do those things, by the way, with existing authority, but particularly where there's the potential for those actions to be perceived as walking around the limitations the legislature set for me last year, I didn't want to just go do that without coming and talking about it. So those are my discrete ideas, those 4 ideas. If we're not going to get to talking about a full PD office or big rate increase, any one of those 4 things would help. All of those 4 things would help a lot.
Thank you. I see we have a question. Go ahead, Representative Thorne.
Thank you, Madam Chair. Attorney Andrus, were you speaking 250,000 for the 4 categories plus field supervisors? Is that package at price?
They're they're slightly different things. So in my imaginary universe, I would have a cadre of attorney supervisors. They would be employees and they would not have caseloads. Their responsibility would be to oversee and mentor and support the attorneys in the field, whether they are assigned counsel or hired counsel, by the way, that goes it works on both sides, because again, once we start looking at the caseload as like a point value, we can assign however much of it we want to either side of the supervision required remains constant, because we need the same number of attorneys to get the work done, or attorney full-time equivalents to get the work done. So that would be, I think, ideal, and I think it's constitutionally required. I think that's where we need to get to eventually. The people I'm talking about with these contracts is much more limited. One of those 4 sets of contracts, it would be one person to start. Maybe if it worked, we'd expand it. That person would be doing some of that field supervision, but they wouldn't be able to do it so broadly. They'd be geographically somewhat limited, and certainly limited by time to the number of cases they could have a hand in.
I'd like to follow up on the comment you made about the contracts to specialists, let's call it that initiative. You said you think that you might already be statutorily authorized to hire those people. Can you elaborate on that? What you think the ambiguity is, what would clarify your authority to do that, and what you think the fiscal note would be?
Sure. So some of the work those people would do would be specific to a case. Let's start there. This is the easiest part. Those people would simply bill to that case. Okay. The other work gets more complicated, because my enabling statute tells me basically that I can pay people to provide direct client services. I can have assigned counsel or contract counsel. Not clear what somebody intended when they drafted it as that distinction, because fundamentally everyone we have is a contract counsel. But that's what the language says. However, I generally have the authority, and I don't have a statutory citation, but as agency operations, if there's an operation that's essential to the agency, then we can contract to do that. These would be contracts that we put out to requests for proposals, contracts that went through procurement. There's going to be oversight of that part of the mechanism. In terms of what would be clearer, I'd have to find the citation, but in the statute that says what I'm authorized, or we're authorized to do, probably both, a provision that said including contracting with individuals to provide necessary appropriate support to the practice. Something like that would make it clear. The existing immigration law contract doesn't necessarily implicate this issue, because everything this person does really relates to a client who may have an ambiguous status. We have had historically a mentorship, we call it resource council program. It needs to be revamped. Not satisfied with the way it works, but those people do get paid at the attorney rate for time they spent counseling their peers, rather than counseling about work, rather than for direct client services. So there is a precedent for it. A year ago, when I thought I was a short-termer doing triage, I would have said I'll beg forgiveness rather than permission. And I think I would have been okay, but I think permission is appropriate, or asking for permission is appropriate.
Thank you very much. Those are really helpful, concrete suggestions. And if you have the opportunity, and I know you're being pulled in a lot of different directions today, if you can send us a quick note with the cite to that the particular statute that where you think the amendment would need to be made.
Yep.
And I know you have sent us some material already in that short 10-minute break, and we really appreciate that as well.
We began preparing, just for framework in terms of what we can provide for you. We actually began preparing for the next budget cycle, not anticipating having this conversation, which we're really happy. I'm really happy. We're all really happy to have. But as we do this, we have much harder numbers than I had a year ago when we had these kinds of sessions. And so if anybody wants to know anything, just send me an email, please. I'll be very happy to put it together. I don't know if it has to go through Peggy or not, but I'll answer. Because we can really show you at least on a historical basis, how many lawyers it takes to do the work, what we need, what they need for support if they're employees, all of that sort of stuff, in a way that is really different than I think anyone's come before. Everything before has been very amorphous and sort of loose in principle. And there's always the risk that the caseload changes tomorrow, but we can't insure against that risk. But we are certainly prepared to be much more precise.
Thank you very much. You've gone over with us, I think, your 4 top priority initiatives, which we are very grateful for the information. Are there any, have you given us your priorities, the commission's priorities, or is there a complete overlap between those 2 sets of priorities?
So I met with the commission yesterday, and the commission blessed these priorities. And so, they haven't replaced the overarching priorities, our effort at pragmatism. So I keep saying that, but I want to be clear that this is building a really good room or a set of really good rooms in a house that still needs a renovation. And so the commission and I persist in the broader request that we evolve the system generally, and that we fund it so that there's parity with the prosecution function. And I keep hammering on that, but it's really truly disproportionate, and that affects things at levels that I wouldn't have necessarily realized at the outset. I mean, it's a morale problem, among other things. It's hard to get people to do this good work when they feel like they're whistling into a hurricane. And so it isn't just a fairness thing. It's a quality of client services thing at the end of the day. I guess I'll stop there, but I just want to be clear. But so the commission has blessed these. These are requests of the commission at this point, in addition to my requests.
Thank you. And I think that there might be some more questions or follow-up. Senator Keim, go ahead.
Thank you. I have a few, just clarifying. So if we talk about one initiative, so you said you have 4 initiatives, but I don't think I quite understand what those are if we limit them to 4, because if we put one under the heading contracts for specialists, which you mentioned, appellate work, oversight, diversion specialists, mentoring, and co-counsel, that's 4 in itself, but they sort of have an umbrella term. And then but when I kind of reflect back on what we've already talked about, it seems that also an initiative that is a priority for you is the flying squad. And so the other 2, I didn't know if they were priorities, is something maybe about a training budget, and then routes to entry.
So routes to entry, in my view.
So could I just interrupt you for 1 second and say, could you tell me if we have 4 initiatives, I guess I need to understand first what those headings are.
So my 4 initiatives today are the flying squad.
Okay.
Legal research materials, training budget, and contract authority and budget. That's where I get the 4. Under that contract, there were 4 ideas that I raised. So I'm sorry for being unclear about that. And then routes to entry wasn't its own initiative here. Couple of the contracts support that in 2 different ways. One, by bringing people in and training them. As part of that, by the way, should it become relevant, I really support and endorse the idea of the Aroostook County Clinic that the law school is talking about, for the same reason, trying to get people into practice. We won't get all those people up there, but that area needs all kinds of lawyers. So
could you just restate those 4 again so that I make sure I had the wording right? Because it helps me to be able to refer to them using the same language.
Okay, so the flying squad, legal research materials, training budget, and contract budget and authority.
Okay, that's helpful. Thank you.
Representative Harnett?
Thank you. And I don't mean to confuse the issues, Director Andrus, but before you got to the flying squad, I thought you started with parity with prosecution. That is not in your 4 top issues that you're presenting?
I'm sorry, I'm been unclear or too far down one of the channels. In a grand scale, at a universal level, there's no question that parity with the prosecution is an absolute requirement for a truly effective and adequate defense system. Parity with the prosecution means funding and resourcing, but is somewhat more agnostic to execution. We could get there in a number of different ways. And I keep talking about, perhaps unclearly, about having quantified the caseloads, because it allows us greater flexibility in thinking about how parity is then applied. That is the overarching need of the defense system. With that, in my view, we need at least some paid defenders, and maybe ideally statewide defender system. That statewide defender system could take any proportion of the cases. It could take 10, 20, 50, 100, probably not 100 because of conflicts, but of the cases. And because we've done this quantification of the caseloads, we can look at it in terms of FTEs and we can allocate. And it doesn't even need to be the same in every county. It could be 80% private, 20% employed in Aroostook County, and the inverse in Portland or something. I'm not hostile to Portland's bar. I'm just saying it could be different. Those things are our grand master plan, and they are high priorities. At the same time, recognizing that we're in year 2 of the cycle, we're in supplemental budget land, that we are in constrained days. I also bring my 4 hit list things that are as discrete as I could make them and carry with them the biggest efficiencies in progress for an amount of effort and money. And so that's how I arrive at those 4 initiatives as what I brought forward as new things today. But that's just a sub piece of that broader need to bring about change. And
so that umbrella of parity with prosecutors is over all of all those other things. Okay.
Yeah.
Thank you.
When I look at the expenses attorneys spend to have the things that state employees have, and I'll tell you, when you see that memorandum, I've built in for them state holidays and vacations. That parity means having the ability to actually regenerate. They come in at $107,000 a year deficit compared to the state's investment. This per full-time equivalent, the state's investment in a prosecutor. So that's a big deal.
I see that we have another question. Representative Moriarty, go ahead with your question.
Thank you, Madam Chair. Mr. Andrus, I feel like a real jerk here putting this question before you, but as I take notes, I try to come up with sort of flow charts as people go through their various major points. And I think I'm struggling, as perhaps Senator Keim and Representative Harnett were, in figuring out, are there 4 priorities, or is 4 a subset of a bigger part of the flow chart? I'm getting turned around continually here.
So there is at some level one priority. The one priority is to provide adequate indigent defense to everybody. And that means next as a priority, funding and resource parity and training and support and all of the things that are necessary for that parity beyond just numbers. So that's up here. All the way sort of at the other end of the flow chart of operations, the 4 things that I brought are the 4 most discrete, cost-constrained, implementable things I could think of. if I had a magic wand, I would start with the funding, overall funding.
Okay, let's make this a real work session. As a practical matter, what do you propose that we report out in the next week and a half? And that, if you can't, I mean, that's asking an awful lot. And if it were tomorrow or the day after that you wanted to sift through that's okay. But you see the dilemma that we're mutually in here.
And I have the same dilemma, right? So if I had a magic wand, I would say, I have some numbers on this, and they're big numbers. I would say, look to the cost of prosecution and investigation and give the defense function that much money. Report that out. I would say, stop the biennial budget process for MCILS. I would say, stop the supplemental budget process for MCILS. I would say, fix MCILS's budget statutorily an amount equal to those budgets. It's a really big number. That's what I would ask you to report out. But at the same time, I'm a pragmatist. And I have learned over the last year not to let the perfect be the enemy of the good. And so if I can't have that, and I can't have that, I know that, I ask you to report out the 4 things that I have brought as discrete, because they're doable on the time frame that we have, and they'll really help. Even when we come back for the next biennial budget, I'll be back to talking about that great big number. So I'm trying to balance what makes our world perfect with what might I be able to have today. I don't want to either ask for the stars and alienate you, nor do I want to under ask and leave an opportunity for progress. And so I will take my guidance as I have from my conversations with each of you at times, or with you as a whole. But if I could have one ask, it would be match our budget to the state's investigative and prosecution budget, and allow us to hire the people we need to make that program work, which is going to be some public defenders everywhere and a robust private assigned bar.
Justin, thank you so much for all of the information you've given today. You've really given us a lot to think about. And Representative Moriarty, I really appreciate your reminding us where we are time-wise relative to the end of the session. I do feel like we've got the information we need as a committee to think about what our proposal will be and come up with a plan. I kind of feel like we need to let this information, give ourselves some time to think about the information we've received. And I know that Justin has sent us a lot of information via the memo that he just recently sent to us. And so I'd kind of like us to, this feels like to me a place where we've identified the issues and the kind of Justin's list of 4 most impactful things that we could do this session. And I think we've also got the sort of big picture proposal, which is the parity with prosecutors. And I personally would like to have a little time to think through that. And I'm hoping that other committee members feel that same way. I don't want to cut off any questions. And so I know that Representative Babbage and Senator Kime both have their hands up. And so let's take those 2 questions and then maybe end this work session with the thought that we will find time most likely next week rather than this week, because our schedule this week is so full, but that we would reconvene next week on these issues. Representative Babbage, go ahead.
Thank you very much, Madam Chair. Thank you, Mr. Andrus, Justin, for what you shared with us today. Perhaps I need to refresh, but I haven't access to the memo yet. So We know that we've just gone to $80 per hour. That probably still puts us 50th in the country. I don't know, the last time I looked, it was, the average is far, far higher. But the number will still be large as we increase that. Yet you've identified execution goals that seem to be quite important, although, you know, we're talking in the vicinity of $1 million for the four. If we had $5 million to put toward, and I don't know what the numbers are, but I'm saying if we had $5 million to put toward greater parity or increasing the 80 to a larger number, would you prefer to take $1 million of that and apply it to the execution goals to ensure that we can deliver a better product? I'm looking for a priority on, it seems to me you put a great deal of time into those execution goals, and they sound very good to me. But also I understand the big picture and we need to provide that motivation. I just wanted to know if that is similar thinking that you have.
I would put the money, if there was limited funds, I would put it toward the execution goals. And the reason that I would do that is, although I don't want to deprive council of increased revenue, if we're looking for, well, I guess it depends what the budget is. If we could get to $100 an hour, that would probably be an important priority. If we're going to get to $85 an hour, the execution goals are probably more important. And so I'm not sure where the break point is, because I can't do the math fast enough in my head. But from an operational perspective, these four goals were, and I like execution goals, that's a really helpful term. They were designed to be executable and discreet and not cheap, but reasonably priced and efficient. I said efficient earlier, really to be the greatest cost and time efficiency.
Thank you, that helps. Thank you, Madam Chair.
Senator Keim, did you have a follow-up or are you all set?
No, I was only going to just agree with your sort of overview of where we're at and say that even I think that we have shifted a lot, you know, talking about MCILS, but it's evolved, and I'm okay with things shifting and changing as you know, our executive director is still making changes, and so there's sort of a shifting dynamic that's happened. Still relatively new on the job, but you know, I appreciate how you keep looking at where the best path forward is. And even though maybe the best path forward has changed a little bit, I think that you've done very well keeping us sort of abreast of what you're seeing and what the dynamics are. And, you know, I appreciate being able to partner with you in addressing the needs and making changes where they're most beneficial. And I see really a lot of the changes that you're creating really does start to, in my mind, create a public defender office in a way, because we're creating more positions and we're taking on a larger role. And so I think that these sound good, like good steps forward. And I agree with Senator Carney that I think we need time to let this sink in and think about it and figure out what our role can be in this. But I appreciate the conversation today. I think it's been very insightful and helpful. And I know a difficult day for you to take this on, so I appreciate that as well.
Thank you.
Thank you, Senator Keim. So committee members, we do have, let me just check in with Peggy, because we have another presentation at 4 o'clock. And actually, before we do that, let's just take a moment, and Justin Andrus has just disappeared. But Justin Andrus, thank you so much for all of your efforts on behalf of MCILS, and especially for your being with us this afternoon on an afternoon when you were obviously pulled in a lot of different directions. We really appreciate your hard work. And with that, we'll close the work session on MCILS issues. I just want to check in with Peggy on the presentations for 4 o'clock, or the FLAC presentation at 4 o'clock?
Right, the FLAC discussion, we have 4 of the 5 available right now. We had originally planned it for 4. I mean, yeah, at 4 o'clock. So I'm not sure if you want to start with the 4. It's a good group of kind of diverse perspectives from FLAC that you'll both benefit. You and FLAC will benefit from a discussion. I think I know that Judge Kelly is already in the attendee space, so I don't know what to say. Yeah, four of the 5 are available right now.
Okay, well, I have a suggestion, which is that we could take a 5-minute break, reconvene at 3:45, and at that point, perhaps the 5th will be closer to joining us, and then we could start then. So committee members, if it's okay to be in recess until 3:45, that would be really helpful. And just as a reminder, the FLAC is coming to speak to us about, we had asked them to look into the scope of preliminary injunctions in family law matters. And so we'll be hearing from them on that shortly. Representative Evangelos, can we take your question when we come back?
It's a 10-second question.
Okay, go ahead.
If the committee brings forward bills, do we have to go through the Ledge Council with those bills?
We have authority to report out legislation in response to the annual report. And so that is the source of our authority to report out the legislation. It does not have to go through the Ledge Council.
Thank you.
See you all in 5 minutes.
Let's see.
I'm just going to check with Peggy to see if all of the FLAC folks are available. Oh, hello, Peggy.
Hello. It would not, anyway, everybody's having technology issues. I see that 4 members of FLAC, Judge Kelly, Melissa Martin, Tim Robbins, and Catherine Miller, there's number 5, Ed David, are all there in the attendee room. And we were kind of thinking of this as being more of a discussion than a presentation, although I think the first thing that will happen is I'm hoping somebody from FLAC will be able to talk about their report that they submitted pursuant to the resolve. You directed them to look at preliminary injunctions. Do you want me to bring them over? Or did you want to bring?
I can bring them over. I don't mind doing that at all. And I don't know if committee members need a refresher as to where to find the report, although maybe looking at the report isn't as important as listening and discussing. So, but I'll begin by bringing them folks over. Thank you.
And while you're doing that, I will remind folks that this morning early, I sent you the report as well as the current law on preliminary injunctions, the original bill that Senator Bailey sponsored last year and that Representative Cardone co-sponsored. And if you remember, they were part of the hearing and were pointing out that the bill wasn't perfect and it needed more work. They've both been invited to this, but they are both in appropriations public hearings right now. So those are documents that I am happy to share with you, but maybe the best thing is to maybe let Judge Kelly talk a little bit about their process of what they worked on, and they were not able to kind of answer all your questions because it's specific and amorphous at the same time. And so they ended up coming to the point where they decided they needed more guidance from the legislature as to what you think is necessary to be in the statute with regard to preliminary injunctions. And I would guess that Judge Kelly might be the best person to talk to you about what a preliminary injunction is and when it's used and why. And they're the practitioners. I'm the one who writes the laws, so I rely on them to give you the actual story in all of this.
Okay, thank you. And I think I brought everybody over successfully.
You did.
All right.
Did.
And I'm not seeing Judge Kelly. Am I missing?
It doesn't say Judge Kelly. It says Ethna Mary Kelly. She's over, and I'm hoping she will turn on her. There she comes.
Oh.
Judge Kelly is the current chair of the Family Law Advisory Commission.
Okay, thank you. And thank you for that suggestion as to how we should begin.
She's not using judge for political reasons, so that she's not crossing judicial and legislative boundaries.
Gotcha.
Thank you. Thank you.
Thank you for explaining that, Ed.
Yeah. And I see 2 committee members have hands up. Are those residual hands or new questions? Representative Babbage?
I think Chris's was up when we came back on from the break, so I think that was old.
Okay, and how about you, Representative Moriarty?
It's new.
Okay.
Madam Chair, what I'm missing is the resolution from the end of last session. I don't frankly remember what we asked FLAC to do. So I think that would be helpful. And I want to confirm that the bill from last year was converted into a resolution and was not otherwise carried over. Am I correct about that?
You are correct.
Okay, so there's no bill pending right now.
There is no bill pending right now. You have authority to you have authority to report out legislation based on their recommendation.
Right, but there isn't one. So I'd like to see what we ask them to do.
Okay, I'll be happy to share my screen. And right now, Judge Kelly's having a problem. So maybe Judge Kelly, she's not here. Yeah.
Okay. Actually, it would be easier, I think, to forward the resolution if that. I can't.
Steve, if you just look at LD 1102.
Yes.
That
is it there?
The version as passed.
Yes.
On the legislative website, that's probably a quick way to get to it.
All right. Okay.
I'm also happy to email it if that's easier.
Well,
it was one of the things emailed.
Anybody else? Am I alone here? I just really don't remember what the task list was.
It was in the email this morning, but I can send it again.
It was there?
Yeah, I just printed it out.
Really? I thought I printed everything off.
There should have been 4.
I do have 4 things, but
7:33 a.m. Yeah.
It's
no, but that's not the resolution.
It's a resolve.
I have a 7:33 email, but I don't have a resolve with it.
Okay, I will find it.
Yeah, there's 3 attachments.
Yeah.
You only had 3?
No, I mean to that particular one, yeah.
I had 4.
Did
I
you
had
have
4.
Huh.
I'm with Lois. I had 3.
But I have the bill. Who knows?
Representative Moriarty, sometimes your email will only show that there will only show 3 PDFs, but underneath it will say there's 4 total, and you can click on that.
I would be the first to admit that I could have overlooked something.
Okay.
Well, I just sent it to everybody again, and it
Okay.
doesn't have a title in the subject, so you'll know that one's mine.
Okay, that's good.
Okay. So, okay, is everybody all set? And I think Judge Kelly is trying to log back in. Maybe I know that there have been technical difficulties that have impacted participants all afternoon.
Right. I could also tell you that the other 4 people who are here, Tim Robbins, Melissa Martin, Ed David, Catherine Miller, are all or have been practitioners and could start out. One of them could tell you what the preliminary injunction is and how it works.
Okay, let's start with introductions, because we are very delighted to have you joining us. We appreciate all of your hard work in response to the resolve. And I'll just call on each of you to introduce yourselves, and then we'll dive into the discussion. And Tim Robbins, let's start with you.
Thank you, Senator. I'm Tim Robbins, and I am currently the executive director of the Kids First Center in Scarborough. Took on that position about 3 years ago after practicing family law for 30 years. So I'm actually not actively practicing. I think I'm technically the public member of FLAC, but so I come to this with a long history of practicing in the state, but currently am not. And I'm thrilled to be here today.
Thank you. And Melissa Martin?
Good afternoon, everyone. Melissa Martin. I sit on FLAC as the legal services representative. I am an attorney at Pine Tree Legal Assistance. I work in the Mid-Coast right now, but I used to work in Cumberland County and York County. So I've worked kind of all over the southern part of the state at this point. And my funding, since I started at Pine Tree, has meant that I represent pretty much exclusively domestic violence and sexual assault survivors. So that's sort of a part of what I bring to FLAC in thinking through family law issues.
Thank you. And Edward David?
Thank you, Senator. My name is Ed David from Farmington. I've practiced family law exclusively for over 40 years. I've retired from private practice representing clients and have transitioned to being on the roster for court mediation in family matters, and I'm doing that. I've been on FLAC for many years, and I'm also was on the subcommittee that's been working on this issue of the preliminary injunction through all the drafts, starting back last summer when we began to pay attention to the resolution to advise you as to LD 1102. And so I'm full of opinions about it, but that's who I am.
Thank you. And Catherine Miller?
Thank you, Senator. I'm Catherine Miller. I live in Cape Elizabeth. I am a family lawyer in Portland, Maine. I am a managing partner of a law firm called Miller Asen. We focus exclusively on family law and estate planning. I've been practicing for approximately 25 years. I am the FLAC representative who represents the Maine State Bar Association's family law section and bring to the group the views of many of the family law practitioners throughout Maine.
Thank you. And then I see that Judge Kelly is just about ready to join us. We'll give her a chance to introduce herself. And I know that Representative Hagan had just rejoined the committee this afternoon. Representative Hagan, did you want to introduce yourself as well?
Sure. Thank you, Madam Chair. I am David Hagan, House District 101, Hampton and Newburgh. Thank you. Did I do it?
You did. We're now waiting for Judge Kelly's technical difficulties, and
all caused by the tie.
just a minute, everybody. We will have this. I'm confident that we're going to get it squared away shortly.
Says that she's on mute. I hope she sees that.
Yeah, it does. And I've been sending messages from my end to see if I can help unmute, but I think it might be something else. We'll just give her a minute.
Senator Carney, if you'd like, Melissa Martin can start out.
Yeah, that's a great suggestion. Thank you, Peggy. Melissa Martin, would you like to start us out?
Absolutely. I'm happy to give you a little bit of background just to review how we ended up here today. And then I'll obviously invite Tim or Ed or Catherine to jump in and provide any details that I missed. But I'm happy to give you guys a little bit of background just to place us, because I think it's been a long journey to get to this place. So this was originally started with a bill that Senator Bailey had presented to you all that was largely, and when we looked into this a little bit more as FLAC, we had asked Senator Bailey, what the impetus of her proposing this bill was. And it turns out one of her constituents is Dana Prescott, who's a longtime family law practitioner and sits on a lot of national committees. And what he had noticed was that he felt like Maine was sort of behind in that our current preliminary injunction in divorce cases is fairly limited. And I'll come back and talk about that a little bit. And what he noticed as a national trend is that preliminary injunctions are getting more detailed. And when FLAC looked into this, we noticed this as well. It's not necessarily always happening in state statute. It's sometimes happening as a court rule or as a regional rule for a particular county. But we are noticing, and in fact, this national trend, I think, where states are putting forth more and more particular preliminary injunctions. So I'll kind of talk about what Maine's looks like right now and what Senator Bailey's what her proposed bill was, and then what the FLAC report was about that bill. So currently in Maine, we have what I would say is a pretty broad overview of a preliminary injunction. There's just a few provisions in it, and it sort of makes broad statements, and some of them I think are can be interpreted in a number of ways. So one that we sort of identified as we were working more is the preliminary injunction as to children, for example, says you can't restrain the liberty of a child. This can be interpreted in a lot of different ways. So it's something that is open to a lot of interpretation. Something that we've also noticed in Maine is that violations of this preliminary injunction that we have in place now are not something that's frequently litigated. So I would say, sort of one thing that we noticed is that our preliminary injunction isn't very specific and it isn't often litigated in our cases now. What Senator Bailey's proposal had brought forth was to take a law largely based on an Oklahoma statute that has a lot more specific rules, particularly when it comes to financial issues, about what a party is prohibited from doing when their divorce is pending. And so there's a number of specific provisions in this Oklahoma statute that was part of the original bill that talk about things like health insurance and retirement accounts, and really lay out the specifics of what is expected from a party when their divorce is pending. When this bill came out, the suggestion was made, should we get FLAC's input on this? And so this is how that bill ended up at FLAC. And we had asked for more time to kind of look into this and to talk to different stakeholders and make some recommendations to you. And with this, I think we sort of opened a can of worms, was what we realized. So we spent a long time, meeting with several stakeholders, discussing this over the course of several FLAC meetings. We looked into what other states have done. And ultimately, what we realized is that in looking at the preliminary injunction and in trying to revamp it, it really touches on almost all the issues that we struggle with in family courts in general, of what do we do with finances? Like, what should the status quo be? What should the status quo be with children? And sort of this broader issue of how much do we want to be prescriptive to parties in a family court case about how they can or cannot communicate with each other. So it sort of touches on, all of the issues I think that we struggle with in family court. And we really got to a point where we were having a hard time reaching resolution on a number of sort of significant issues, and felt like it would be helpful to come back and get some guidance from the committee about sort of big picture questions about what direction we should take. And so at this point, I think, well, I want to ask Catherine or Ed or Tim if they have anything to add to sort of that summary of how we've gotten here. And then I see hopefully that Judge Kelly, it looks like she can hear us now. So I might have her talk a little bit about the questions that we've posed in the report based on getting to this point of struggling to reach consensus on some of these bigger picture questions. Tim or Catherine or Ed, do you have anything you want to add to my summary of that, how we got here?
Yeah, thank you, Melissa. I think it's an excellent summary. I think we ought to let Judge Kelly review the more specific questions to the committee, because it must be very uncertain to you as to what direction to give us. I personally am in the more activist camp. I think our preliminary injunction is an opportunity to raise the bar, to bring additional civility, calm, and lack of disruption to the situation, and try to keep children out of the middle of it. The key to that is early intervention from the judiciary. Often I favor a case management conference addressing some of these issues. We actually had fairly complete agreement in FLAC and stumbled over a very thorny issue about attorney's fees and how whether you could try to put that into the preliminary injunction, but the initial separation, as family practitioners know, is the most volatile time when crazy time is going on, assets are stolen, children are hidden, all of those things. So I think we had an opportunity, and we do have an opportunity with your guidance to improve, as I say, the civility and raise the bar in family law cases. Thanks.
Judge Kelly, are you able to hear us now?
Yes. So hello, everyone. I'm so sorry that my computer wasn't allowing me to unmute, but I'm on the phone. You can see me on the screen. I hope this works. I know it's not ideal. So thank you for allowing us to talk with you. I sat in on the end of your hearing on indigent legal funding, and I thought, oh no, they're exhausted. That's a huge issue, and here we have this other issue about preliminary injunctions that really is so little in comparison. But it also, as I think Melissa might have told you, and I'm sorry I didn't hear Melissa's comments, so please forgive me if I'm repeating a little bit. And if I could go back a little step just to talk. I mean, a lot of you on the committee are lawyers, so you know all this. So but just bear with me so that everyone can have maybe a common understanding. So let's take a case where a doctor is being sued by a patient. In that doctor-patient litigation, there's no automatic injunction. Nobody, the legislature isn't involved in regulating the life of the patient or the doctor in relation to their finances or in any other way. Family cases, we've decided years ago, are different, and we have what we call an automatic preliminary injunction. So the moment I, as a plaintiff, file a divorce case, things are frozen by that action. And so right there, you can see the person in control who's bringing the action is already in a bit of a dominant position because they know they're going to get divorced, and they've arranged their lives perhaps accordingly. And so it's from the moment they file, though, that things start to be affected by the preliminary injunction. And what does that mean? It means that with very little movement, and we have already a statute that allows for some things to happen, but essentially we're trying to keep the status quo so that you can't give money to your girlfriend or to anyone while after you file the divorce. So we're trying to conserve the family's assets, and indeed all of the assets of the party, because we haven't figured out yet who owns what. So that's really what a preliminary injunction is. So the statute we have right now is quite narrow, and I think initially Senators Bailey and perhaps Representative Cardone thought we should expand it. And so we started to work on that. They, I think, had concern, Senator Bailey, especially about health insurance. We don't want people canceling their health insurance when there's a divorce pending, because that has traumatic effects for families and real financial loss. When we started to work on it, though, we really struggled with how far we should go with the preliminary injunction. And I think you've heard from Ed that he was one of the proponents of a pretty broad injunction. And there's a lot of merit to that. But remember what we're doing here. We're saying certainly the law, the legislature, should intervene in that relationship between husband and wife ahead of the court doing anything as an automatic matter. And so what we realized, I think it's exactly, I did hear Peggy's opening comments before I lost you, was it's amorphous and it's very specific all at once. And the more we say people can't do things, that's making a very broad swath of legislation that mightn't really be helpful for a particular family. For example, if we start to say you can't relocate, does that mean you can't move from Portland to Presque Isle while the divorce is pending? Or is it just Portland to New York? Is it just out-of-state travel? What about the victim of domestic violence who needs to move out of state very quickly? Does this, if you take this very broad approach to preliminary injunctions, are you going to do injustice to people? And might it be a while before a judge could come in and do something different? So most of these preliminary injunction provisions, whether in Maine or elsewhere, have language that says the two parties can agree to do something differently, or a judge can order something other than the automatic injunction. It'll take a while to get to a judge, and obviously in a lot of situations where people are divorcing, they won't be able to reach consensus. Melissa touched on the attorney issue. Should parties be allowed to have access to funds to pay an attorney? Should there be any limit on that? Should I be able to take out $50,000 for my attorney? And what if that leaves you with nothing? If one person gets $60,000 for their attorney, should the other person be given the same for their attorney? So it seems such a really a little issue, and you must think we are odd to come to you and say, give us some guidance. But we felt we really needed to kind of have this or hope we could have a conversation with you, and you would say to us, well, why don't you give us a range of possibilities and explain to us, you know, what you're trying to do with each of these, and we'll decide. But give us the legislation in draft form so that will be easy for us to make a choice. Or you could give us more direction and say, we really think there should be some kind of a preliminary injunction that relates to movement of children, use of finances. Should there be language saying neither spouse can harass the other spouse? Is that a given? Should that come in the form of an edict, or should we encourage people how to behave? The other thing to say very quickly, and I don't want to monopolize the conversation because other people did an awful lot of work on this. They're here with you too, and it can give you a lot more wisdom than I. But when there's an injunction in place, there has to be a consequence if the injunction is violated. And theoretically, that's a contempt power. The court can punish the violation of contempt the violation of an injunction, by using our contempt power. Quite frankly, that has rarely happened. But if we make this very expansive restriction on what people can do before their divorce case is heard, it only matters that we do that if there are teeth to that. And then if there are teeth to that, that's going to create a lot more litigation before the divorce even gets underway. So I would say among the judge body, there was probably a range of opinion who liked what we were doing, and those who said, look, you're creating more problems. We have enough litigation. Don't make it any more complicated. But also people recognizing that sometimes at the end of a divorce, there aren't enough funds, or things have been done that have had real consequence for one side, and there should have been instruction to people at the outset, don't do certain things. And then we also recognize that for the language to be enforceable, it needs to be really clear, because a lot of people don't have lawyers when they file a divorce. And you know, that was another complication. So all by way of saying, we all felt very poorly that we were coming back to you and saying we haven't really done what we had hoped to do and giving you clear guidance. But we realized that there were grand philosophical issues about the role of courts, the role of the legislature, about money, about lawyers, about how involved the legislature should be in regulating the lives of people when they decide they wanted to get divorced. And so here we are coming back to you. And Tim and Melissa and others jump in, because obviously we've all been part of this long conversation, and you've all done a lot of work on this.
Yeah, I'll just jump in briefly, Judge. I think you summarized where we are in FLAC perfectly. For me, and I guess I'll speak for myself here, why I want to be part of this meeting is that I'm really kind of going back to basics. What is the problem that we're trying to solve? And I think part of that is getting some direction from the legislature. Peggy, thank you so much for sending Senator Bailey's written comments to us. That was very helpful. But I think I think we've struggled on FLAC of what is it that what problem are we trying to solve, and then when without enough guidance on that, we all have our own perspectives, our own experiences with the injunctions and say, well, I may see, well, this is a problem that I see needs to be solved, and Ed and so on and so on. But I think it's most important to me to know what problem the legislature wants to solve, as opposed to what individual members of FLAC wish to solve. So for me, it's really coming back very basic. What's the problem? Are there other ways to solve it besides amending this statute? And there may be. So I'm here more to listen than to talk.
Thank you. And Representative Rick, before we take your question, let's give Catherine Miller a chance to contribute. I think she's the only member of this group who hasn't had a chance to weigh in.
Thank you, Senator. I think that the points are all well made. There is interest in almost every section through FLAC to improve the statute, but there is varying degrees and somewhat inconsistent as to how this can be a more fine-tuned statute without overreaching. The problem that I saw among the family law attorneys, and whom I circulated the draft, was largely, how is this going to be enforced? Where does this fit in without increasing litigation time? We don't restrict other areas of other types of actions as significantly. I realize the family cases are very different, but we also have to keep in mind we're impacting people's use of their money. Preliminary injunctions are a legal vehicle that has a lot of strength and teeth. So I want to make sure that what we're doing to main families is well thought out, and we are really fine-tuned on the problem. The family law section largely thinks that the existing statute is somewhat outdated, but it covers the areas that we need to, with the hope of getting into court quickly where we can bring order. What the hope is that the preliminary injunction statute isn't used in place of interim orders where we're allocating fees, no, excuse me, not fees, but cost. Some of the details, for instance, if we were to say that auto insurance was to be maintained, we could have the impact of this assigning cost to one side that may not be able to bear it. Now, I realize we can get into court and change that, but at some level, we have to be careful of the impact on one side. There's always going to be examples where the statute is great for one side, but then it can be harmful to the other litigant. With that, I think that Attorney Robbins' comments were well taken. We really would like to address how can we have the best statute for Mainers and not create more of a problem than we need to create in a time that's very difficult for them.
Many thanks to all of you for your thoughts. And I think there are going to be some committee questions. Representative Recca, go ahead.
I'm sitting here as one of the non-lawyers on the Judiciary Committee. On the other hand, I spent my whole life dealing with domestic violence victims. So I can't leave that perspective somewhere else. It's embedded in my head. And I confess to my ignorance about what is possible to do under a automatic preliminary injunction. And I'm interested to know that has subsets that I have never looked at. And I intend to try to do that at some point, or at least be advised on what's in there. But I think that the thing that worries me, and I don't have any problem with a well-articulated preliminary injunction statute, and it may be we have one already, or it needs to be expanded or contracted. I have no idea. I've never looked at it. But I do know that it's helpful to me that one of you said that basically the principle of it is to attempt to maintain the status quo and clarify who owns the assets in the family. And unfortunately, there's been 2 divorces going on in my family in the last 2 years. And so I'm really conscious of the issues that have arisen, and some of them have been well dealt with, I think, with the preliminary injunction, at least as long as we pointed out that you should be paying attention to this section, and that I at least knew enough to do. But the other divorce was a much more volatile piece. And I'm thinking about what could be done in the case of case management conferences, which I think are a good idea, but if you're going to have case management conferences in a divorce situation where there is a domestic violence victim or a harassment victim or whatever, you really need to figure out who's in that room besides the two people and the case manager. I mean, whoever's doing the mechanics of it. Because I think that person who is will not, I'm going to say women because that's predominantly the people I've dealt with, don't necessarily have the capacity in their own situation to stand up for themselves in that parameter. So I'm concerned about how articulated case management conference practices are, or should be, or could be, in order to protect people who are not in a position in their life or their head where they can stand up for themselves in an effective way. I don't know if I can say it any differently, but you understand what I'm worried about. And that's more of a worry. In the other situation that I'm thinking about, it was just a matter of my getting some advice and saying, have you thought about this? But this is not attorneys saying, have you thought about this? So I don't know what the list of things people should think about, so that we could advise people who come to us with all manner of problems. As a legislator, I mean, I get questions that I haven't clue one about. So we have to try to reach out and figure out where to send them or what to tell them. And I think that were we to have a good understanding of this particular section of the law, it would be very helpful. I'll be quiet now.
Thank you, Representative. That was a lot of good thought, and I just want to know if any of our guests would like to respond, or should we take another question or observation? Maybe it makes sense to get all of the comments out on the table. Representative Moriarty, go ahead with yours.
Thank you, Madam Chair. This doesn't go to anybody in particular, but as I understand the current law, as was provided to us by Peggy, immediately upon the filing of an action for divorce, the clerk of the court, and not the judge, automatically issues a preliminary injunction, which is standard in each and every case. Am I right so far?
You are absolutely correct.
Okay, so it is a one-size-fits-all roadmap to cover the immediate post-filing rights and obligations of the parties. How about that? Right so far?
Yes, the limit, yes. I mean, not a broad spectrum of rights, but I mean.
Well, yes, as far as it goes, though.
As far as it goes, yeah. So basically, once it issues, each side is, I'm now reading from the statute, enjoined from transferring, encumbering, concealing, selling, or otherwise disposing of the property of either party. So it prevents you from alienating, selling, rid of property, unless you need it to run your business, so the usual course of business, or you need it for the necessities of life, which aren't defined in the statute. So that's,
yes, but I'm just trying to make the point. It's a mandatory minimum order.
Yes, it's a mandatory minimum order.
Sooner or later, as the case progresses and time goes by, you will have people like mediators or others get involved in the case. There may be motions for temporary child support or motions for temporary custody, I should say, parental rights and responsibilities, which I gather would overrule this initial preliminary injunction. And that becomes the law of the case from that point forward.
Yes.
So in the evolutionary change, or it's the evolutionary development of a divorce case from beginning to end, this is the first basic step, and its provisions, while narrow, apply to everybody.
Yes.
Okay. I honestly don't remember how deeply we got into this last year. We must have had a public hearing, and then at some point decided to send it to FLAC with not a lot of guidance, but just your input. And we're now hearing that the viewpoints are divergent and not all over the map. I don't mean to be sort of snide about it, but there are many different viewpoints, and you've asked for more time. Basically, that's the bottom line, it seems, of the report.
But so one approach is to say, here's our report. Sorry, we failed you miserably, or here's our report. This turns out to be a very interesting but complicated issue. Do you want to give us more guidance if you can? Do you want us to keep working on it? Do you want us to give us perhaps a variety of possibilities? It would be helpful if you could give us more guidance, but it's a very hyper-technical issue, so we recognize not be able to give us that guidance since we're all experts in this of some kind, and we've struggled. So we realize it's a big ask, but I think we were saying to you, I've been the chair of FLAC for a few years. We've never come to you in this fashion before. We've always tried to give you a consent.
I know. I understand. Madam Chair, one more question.
Let's let Judge Kelly just finish what she was going to say, and then you can
Well,
ask.
I think we okay.
Oh, I'm fine.
Okay.
Go ahead.
Go ahead, Representative.
So, folks, I don't know necessarily what Senator Bailey had in mind when the bill was filed last year. From your perspectives, is the system broken, and does it need fixing?
All right, I see one nodding head from Edward David. So do you want to respond, and maybe we can give everybody a chance to answer, because that's an important question to ask. Go ahead.
Yes, I think you've hit the nail on the head, Representative Moriarty. I think it's creaking and archaic. I wouldn't say broken. It does what it does, but it's not suitable to the modern times. It's not suitable to the mischief that people tend to get involved in very early on when a case is filed. The destruction of electronic records, the sequestering of children, all of those kinds of things. So as I said, I think there's an opportunity here to raise the bar and to increase the basic requirements that then can be modified within a matter of weeks at a case management conference or something else. So my answer is yes, it needs improvement, and it's an opportunity to improve it.
Thank you. Can I just ask everyone to please weigh in on that question?
Senator, if I may, this is Catherine Miller. I think it's less broken. That can be strengthened. For instance, I think that we should enjoin people from changing beneficiaries of retirement accounts and life insurance, perhaps preventing them from redeeming life insurance policies, which are often carried over through after the divorce, to make sure that we protect child support obligations. But I'm very opposed to restricting how, if they have access to borrowing money during the divorce. The beginning times is difficult. People are separating. They're often setting up two homes. I would be opposed to having ways that they cannot incur debt, they cannot borrow money, or they cannot use their 401k if they need it. And I'm mostly in Senator Bailey's draft concerned about the obligation that one litigant, if used, there are exceptions in the current law to allow people to use them for the regular course of their business or for the essentials of life. If we put on an obligation that an individual needs to give notice to the other side about how they use them, we give the requirement that we have to share more information. We have a discovery process that's through the ordinary course of our litigation. The idea that we would have to put somebody on notice and notify them of how money was spent is adding to the burden that we have already in these cases. So I think in the original LD 1102, there was some language that I would have objected to, but largely I think that the bill had a lot of ideas that were very good. People should not destroy anything. You shouldn't destroy electronic materials. You shouldn't destroy property. So there are things that we can add without restricting people's ability to use their money as they need in the beginning of this.
Thank you. Melissa Martin, just because I see you next on the screen, go ahead.
Yeah, so Ed and I are very in line on this. I also agree that I think there are real problems with the current system. And I think, this is a situation where I think because of the types of cases we're involved in and the clients that we represent, Catherine and I have very divergent views on the attorney's fees issue. So I work at Pine Tree Legal Assistance. I'm working with a lot of people who were unrepresented in their original divorce, or where one party has an attorney and the other side doesn't, or seeing cases after the fact where neither party had an attorney. And a trend that I've seen is, there's a very small amount of marital assets. There's one joint tax return that's a few $1,000s. There is one small retirement account that has $5,000 in it. And one party liquidates that asset and pays an attorney, and that party then has an attorney for the case and the other side doesn't. And then there's this inequity throughout the divorce process. So I think that's a problem that we're seeing happening. And it's a really challenging problem to solve, but it's definitely a problem that I see that exists. Another specific example, I think, of a problem we currently have, I mentioned briefly when I was talking earlier about the language regarding parental rights right now simply says you can't restrain the liberty of a child. I can't even really tell you what that means as an attorney practicing family law. I've pieced together what I think a judge is going to interpret that means from years of practicing. But, our preliminary injunction doesn't say, don't move out of state with your child. It's not that clear. I think those of us who practice family law know that if you want to relocate out of state, there needs to be some pretty specific reasons why. You probably should wait to get in front of a judge and get permission to do that. But it doesn't say it that clearly. And I think, we know we have a lot of unrepresented litigants in family court, and I don't think we've provided clear enough guidance on really important issues. And I see a lot of clients come to me once they've already done something wrong that they didn't know was wrong, because the preliminary injunction currently isn't clear enough to give that specific guidance of, hey, wait a minute, if you're thinking about moving out of state, that's actually going to be, that's a really high burden to reach for a judge to think that's a good idea. For some reason, that isn't common sense to most people, and they don't realize that. And the preliminary injunction doesn't say anything about relocating, moving out of state. It doesn't have any of those key words. It says restrain the liberty, and people don't know what that means. If they don't get access to a lawyer, they don't understand that. And I think that that's a real problem too. And there's obviously other examples throughout the current statute that I think just aren't clear. It's difficult to read. People don't know what it means. And when we're talking about a lot of unrepresented litigants, it's just not effective the way it is now.
Thank you. Tim Robbins?
No, thank you. I guess I come at this slightly different question, but hopefully it answers your question. Is the current statute doing harm to citizens right now? And I think the answer is no. I think I can sleep at night knowing that the current law is not harming any citizens of the state of Maine. Now, it could be on a case-by-case basis. You may find where the injunction may have worked to the disadvantage of a party, but I don't think that I can say that the citizens are being harmed. So the next question is, can we improve it? Now, keep in mind that this injunction only applies to divorce cases. It doesn't apply to the whole universe of family law cases, the parental rights and responsibilities cases. So, and we've talked about how do we expand the universe of cases that this would apply to, at least on child-related issues. So we have financial issues and we have parenting issues, and often, behavior kind of issues, and whether we want to regulate parents' behavior before a case even starts, or at the time a case starts. So I guess I agree with the majority of FLAC that we can make some improvements, but I think we need to be very careful. And I think this is where we had some divergence in making those improvements. Are we going to then put citizens in a position where we are harming them? We have a system now that may not be maybe a bit antiquated, but we're not harming anybody. And we have to be careful not to, in our fixing it, not to create a system where we may be harming or increasing litigation, because I think the whole point of having this is to decrease litigation, not increase it. So I'm not sure if that answers the question, but I do subscribe to the do no harm principle when it comes to these things. And I think to answer your specific question, I don't think it's broken. It's a question of, does it need a new coat of paint? Does it need does it need improvement? But I don't think it's actually broken, but it can be improved.
Can I just ask you, what are the things that you would change to improve it?
Well, from my perspective, it's, and I'm speaking for myself and not for FLAC at this point, that it really, based on what I've done in my career, advocating for children, now at the Kids First Center, really trying to create a culture where parents know where the boundaries. I mean, we have this, I think it's a quite genius statute of parental rights and responsibilities. We don't talk about custody. We talk about these bundle of rights that parents have. And essentially, the basis of shared parental rights is that you don't make unilateral decisions. And so if we had an injunction that says, don't make unilateral decisions, then you carve out exceptions. There's abuse and there's domestic violence, child abuse. There's all sorts of things where we could carve out the exception, but those are the exceptions. So for me, from the Kids First perspective and Tim and Robin's perspective, is it's really laying down what the law already is and really using the injunction as a way to inform of what not to do. Don't make unilateral decisions. On the financial side of things, again, this is where it really only applies to divorce cases, is really trying to maintain some status quo. But again, we need to be even careful there, because sometimes the status quo is one party exerting coercive power and control, and we don't necessarily want to preserve that on the financial realm. If so, we have there, it becomes very difficult that from my perspective, we don't want to embed in the law more tools for abusers to use legitimately in court against their abusers. So I supported the FLAC version, but I support it because we did keep narrowing it down, and I think we got to a point where it was narrow enough to where I could support it. I just worried that we, in our effort to improve, that we create a whole new set of problems that we don't currently have.
Thank you. And Judge Kelly, go ahead.
So I respect all of the views, really. I know that sounds very wishy-washy. I think it could be better, whether it's broken or just could be better. Maybe it's somewhat, for me, a matter of semantics. I don't see it presenting it in cases hugely, but that doesn't mean it couldn't be a lot better. And to the extent I see it, it's often that money has been dissipated and there's no getting it back. So Melissa talks about that $5,000, which for some people may not seem like an enormous sum, but for that family, that $5,000 is the only asset to be divided. So I do worry that as a judge, I can't sometimes undo the things that have happened that were unfair at the outset. And I think we could do better. I do, like with Tim, I think we certainly could have, even if it isn't necessarily injunction language, that we talk to families more and to parents more about the ideals and the way they should treat one another and their children as they navigating this very difficult process of divorce. So I think there's a role for educating parents. I do think, though, there is, I'm not unmindful of what Ed's saying in relation to people getting access to other people's emails and the destruction and the improper use of materials. So I do think our statute is archaic and definitely could be improved significantly. And I'm happy that FLAC would continue to work on that.
Thank you all. Representative Babbage, would you like to go ahead with your question?
Thank you, Madam Chair. There's a lot of education needed here for me, but I guess what I would like to hear from you folks is, as I'm listening, it sounds like you're talking, you're regarding LD 1102 as, I was trying to figure out if that was expansive or restrictive in an approach to reform, but it is pretty much restricted to the financial elements. So, I mean, if you wanted us to pursue with the restraint of liberty clarifications and so forth, certainly we'd have to look at proposed language for that and understanding. But I am interested in specifically your reaction to the language in 1102 and the problems you may see there that would help us to focus at least that far regarding the financial restrictions.
Are you representative? Are you asking the FLAC members?
I heard Mr. Robbins talk
Let
about.
me just finish my
Okay, I'm
question.
sorry. Yes.
Are you asking
yes.
them to actually look at the originally proposed, like the printed version of 1102, and sort of annotate which sections each of them feels would be important to incorporate into an amendment to the law?
Yes, I believe I'm hearing that shoring up some of those financial restrictions is not a bad idea. But I don't know to what extent they're looking at that proposal as expansive or more detailed than is needed. And if there were areas of weakness in that, perhaps that's not our blueprint. Maybe that's not the template we're working from at all anymore. But I think for our deliberation, to see that kind of language is helpful to pare down how we can make improvements without overstepping.
Okay. Judge Kelly, did you have a reaction? Go ahead.
Maybe I'll try here. I think we certainly were very mindful of that draft as our starting point. One of the issues in that draft was it would have allowed specifically for attorney's fees, and that got us into this discussion: is it open-ended attorney's fees? Is it reasonable attorney's fees? So there was one of the issues, and then there was an issue about life insurance. There was some concern that if the victim of domestic violence had a partner who was going to be maintaining life insurance on that person, that might raise some safety concerns. There was Representative Cardone at the first hearing or work session on the bill had objected to a restriction in Senator Bailey's bill that would have prevented people from taking money out of a 401k, because for some people that's their only source of income because they're already retired. So I do think this is a fine blueprint, especially in financial issues, and we can certainly work with it. And then the next question would be, well, do we want to venture into the other worlds, such as relocation of children? Should there be an assumption that children are not to be moved at all during, in the first stages of a divorce, or a judge or magistrate can weigh in on that issue? I don't know if that helps you, answers your question. And if I could, I didn't mean not to answer Representative Reckitt's question too. If you want me to do that at some point, I'm happy to go back to her.
Okay, let's, I think that Edward David has something to say in response to Representative Babbage, and then we'll come back to you for that answer. Go ahead, Edward David.
Thank you, Madam Chair. Representative Babbage, it was somewhat expansive. I'm looking at it. It enjoined people from opening or destroying mail or electronically stored material, electronic communications, social network data, financial records of any kind. It enjoined people from endorsing the other party's name on negotiable instruments. That's how joint tax returns are often snatched as they come back, particularly this time of year. It is 1102 that led us to these topics that I would answer your question as being somewhat expansive. And as you've heard me say, I think appropriately so. I think it's an opportunity to address a great deal of mischief that happens at the beginning of a case. Thank you.
Thank you. Judge Kelly, go ahead.
I just wanted to acknowledge Representative Reckitt's comments, and I think they speak to this issue, the clarity or lack thereof in the preliminary injunction, and just generally about the process of divorce. We know in the court system that in 70% of cases, one side or both sides are unrepresented, and divorce is complex and overwhelming, and people are not sure what steps they can take, even if they're trying to be kind and respectful to their partner. There is room for greater clarity, especially for people who are unrepresented. And in terms of her concern, well, would the person making the decisions be mindful of the domestic violence dynamics? I think once it gets into court, obviously a magistrate or judge is making that decision. And so that person should be very mindful of the possibility for power and control in making assessments that would override the automatic preliminary injunction. I hope that answers your question, Representative Reckert.
Thank you. Okay, I think that we've addressed your questions, Representative Babbage, and then Representative Moriarty, go ahead with yours.
Thank you, Madam Chair. I just wonder, did I hear someone say at the outset that preliminary injunctions are not litigated generally? That is to say, challenged. There are no motions to amend or revise the mandatory language. Did I hear that correctly?
Go ahead, Melissa Martin.
Yeah, I think that was me. So I want to clarify a little bit. I think one of the things that, and Judge Kelly, please correct me if I'm wrong, when we first discussed this on Flack, one of the things I remember members talking about is that as written, I don't think that there are often violations of the preliminary injunction are often not litigated in the current language. And one of the concerns of making the language more specific is that it might lead to greater litigation. So although it would lead to greater clarity, it would also mean that parties couldn't argue, well, it could be interpreted both ways. And I think therefore there's a possibility that there would be greater litigation. And I think I see Judge Kelly's hand up, so I'll let her address this a little bit further.
Thank you.
If the chair wants me to.
Yes, go ahead.
I agree with what Melissa's saying. I think if I could, Representative Moriarty, there's kind of two issues. One, do people violate the injunction on a regular basis? And two, does the person who's adversely affected do anything about that? And then maybe three is, do people ask the court to modify the preliminary injunction? And I think the answer to do lawyers, not litigants, self-represented litigants don't ask us, but there is often a quick hearing at the outset of a case, which will in effect modify the effect of the preliminary injunction. I think what Attorney Martin is saying, which is also incredibly accurate or normal in my experience as a judge, is preliminary injunctions are violated probably on a regular basis, sometimes knowing, sometimes unknowing, unwitting. We have very few cases. I will say I probably have never had a case where somebody brings a motion for contempt to say the injunction has been violated, do something about it, punish the person, because that's another event that's expensive and perhaps, you know, the horse is already out of the barn because the money is gone. But they might ask us, well, please take that into account. If there's other money at the end, in the hearing itself, let's try and make that right. So I haven't seen much litigation about whether an injunction has been violated at the outset with a contempt motion, but it doesn't mean they aren't being violated and that we can't make it right at some point, but not always are we able to do that, if that answers your question.
Yeah, thank you. Go ahead, Representative.
I think what I'm hearing is that the lifespan of a preliminary injunction is relatively short, given the overall length of the case itself. It seems to me you get into the case management conference stage fairly quickly, but tell me if I'm wrong about that. And of course, the parties have the option to file motions for temporary relief pending final judgment, and the orders in each of those cases would supersede the terms of the preliminary injunction. So I'm just wondering if we're worrying about a fairly short segment of time in the overall life of the case that in which sort of the terms and conditions is what, who can do what is determined, but only for a short period of time before the other elements of the dispute resolution process are triggered or take over. I'm curious as to whether this is worth the effort, to put it bluntly.
I'd like to.
Oh, sorry. I'm happy to address that a little bit if it helps. So I think the other complicating factor that we know is there is a process to request an expedited hearing in Maine, not frequently used, and even when it's filed, it's not, we know the numbers are very small of expedited hearings that actually happen. So that's another complicating factor. So I think you're correct, but I don't think that means that parties are actually, I don't think parties are actually in agreement. I think they just accept that things have gone in a way that they weren't happy with, and then they move on with the case.
Thank you. Senator Keim, go ahead. And then committee members, it's close to 5, and I'd like us to sort of start to provide some direction to our FLAC guests today. But Senator Keim, go ahead with your question or comment.
Thank you. And I guess this is directed really to you, Judge. I've listened carefully to the conversations because it is not something I'm very familiar with, thankfully, actually. But one of the comments that you made still sticks with me, and that's the idea that the person who first files has the advantage. And the more that we add into this law, the greater advantage we give to one party. Would that be a correct overview on this?
Not necessarily. I mean, one of the drafts, for example, one of the discussions we had, I'll give you just one example of how we might have in the preliminary injunction language try to redress some of that was to have a look back provision. So let's say you're the wife, you filed first, you've taken $50,000 out to cover living expenses and to hire your lawyer. One approach might be, okay, then the other person is going to, you have to disclose what you've taken out, and the other person is going to have the opportunity to get that same amount or to have that somehow rectified at the, you know, at the time of final hearing. So that was, you know, that, yeah, I think there is a danger that the more complicated this becomes, the more that the person who's filing will get their ducks in a row. That's certainly a possibility. But there might be also an opportunity in this kind of preliminary injunction stage, or just generally to allow the person who hasn't had access to the funds to get a more easy path into court, for example. That's why I think Melissa may have said at the outset, this seems like we're just talking about one really small thing, an injunction, but it really goes to the whole justice underpinning a case in a divorce case. And that's why I think we struggled with coming to consensus about it. I hope I've answered your question by that.
Yes, you have. I appreciate that. And I think the other thing I would ask you, because you chair the committee, is that right? You chair FLAC. Yeah. So would you overall say that there's agreement that improvements could be made, but not agreement on what those improvements would look like?
Yeah, I mean, I think that's fair. I think we all agree that improvements could be made. And I think we're all almost agreed. Well, I think there's pretty wide consensus that we should tread carefully, because there's a domino effect here that we mightn't always even totally anticipate. And then I think there might be some remaining issues where there's just a different philosophical view. And I think that probably the attorney's piece was probably the lightning rod in terms of the biggest area of disagreement as to whether the legislature has any business getting involved in how much people spend for attorneys, and you know, whether there should be some equalization. I think that was a struggle. And then in terms of, I don't want to wander on because I'm mindful of the time, but I think we could come back to you with a bit of work with, here are some areas where we're agreed should be changed. Here's some areas where, yeah, here's two different perspectives. Here's philosophical approach A, and here's the language that would support you doing that, should you decide to do it. Here's approach B, here's the language that would support you doing that if you decide. I think we were starting to feel these were, as minimal as some ways this issue is, that these were legislative decisions of policy, public policy, and what's good for the public and not hurting the public. I endorse Tim's view about that perhaps you were best positioned to make if we could educate you about the issue and get some feedback, and if it makes more sense for us to do more work to give you, you know, here's a few different approaches, and you decide where you think you would like to bring us ultimately. But we do the work for you, we tell you the options, give you the legislation that would support those various options, if that would be helpful.
Okay, thank you. That's helpful. Thank you.
Yeah, I'm just going to jump in here for a moment. I do think that would be really helpful, because I think this discussion has really informed us of what the different policy options might be, and you've given us a lot of direction and information, and that suggestion is wonderful, Judge Kelly. And I think we want to take you up on it, but let's hear from a couple other committee members. Representative Harnett.
Thank you, Madam Chair. Thank you, everybody, for the discussion today. And I think Judge Kelly said what I was hoping to hear and what I wanted to ask after Senator Kimes' questions, and that is what would really be helpful to me is to hear what there's a disagreement as to whether the statute's broken or not, but everyone seems to agree it could be better. Um, the question is, how much better could it be? And what would be helpful to me, I think, is what Judge Kelly laid out, is for us to get a statute that says this is what we agree on. We agree on these changes, but there are these other areas that were in the bill that we have very different policy points of view on. And then that's up to the legislature to decide with the best information given to us as to what the arguments were on both sides of those issues where they could not come to agreement. So I may just be repeating less articulately what Judge Kelly just said, but that would be the best thing for me to see.
Thank you, Representative Harnett. Representative Moriarty?
Thank you, Madam Chair. I want to ask you what your plans are for the late afternoon, early evening. Are we on the threshold of adjourning, or are we prepared to continue?
Well, I think that I kind of feel like we've come to a place where we understand what the implications of the different policy choices are, what the risks and potential gains are of having a more definitive broad versus a less directive. And if we can look at the menu, so to speak, of what those options are, moving from most widely shared by members of FLAC to the ones where there was a lot of disagreement, I think that will really help us make a decision regarding reporting out legislation. So I sort of am seeing us as getting to a good point in our discussion where we responded, I think, to the FLAC's request for some guidance from us.
And technically, this is not a work session.
Correct. This would be, the next step would be for us to receive more information from FLAC and then decide whether we want to report out legislation.
Okay. Well, again, if it is your plan to adjourn, I'll be quiet, but I do have some thoughts as to where we go from here. I just don't want to, interfere or overstep.
Do you want to just briefly share them with us, please?
Sure. In the FLAC report, at one point on page 2, the authors indicated that there was a fundamental lack of consensus. And the final recommendation was, we're prepared to continue working if you want us to. Again, we have a week and a half before we report anything out. I'm not prepared to, I can't imagine that in a week and a half, FLAC can come up with the terminology of a bill, given the clarity of their report that they are not in agreement on many, many points. I would not, at this point, I think, vote on any legislation that substantially changes the current preliminary injunction statute, which, for all its flaws, seems to be doing its job, which is time limited. The only thing I would do is, and the next point is that our resolve from last year has now expired, the committee having delivered its report. There's no bill pending before us, and there's no continuing authority right now for FLAC to pursue. The only thing I would do is consider yet another resolution to authorize FLAC to continue its work to report to the 131st. Because I'm not prepared to vote for anything based upon what I've heard. So that's where I'm coming from.
Thank you. Senator Kime?
Yeah, since we've moved, I think, from questioning to sort of giving our overview, I agree with Representative Moriarty. I really appreciate the forthright discussion and being able to hear the members' perspectives, but there experts in this and have wrestled with it for a good length of time and haven't come to us with something that they think definitively improves what is currently happening. And so I don't see that we have time to take up a measure given the late date of this session. And I would appreciate them, they do work. It is an ongoing committee. It's not one that, ends when the legislature ends. And so, if they had the inclination to continue these conversations, possibly someone could put in a bill next session and we could hear that. But yes, I would agree with Representative that there's nothing that I would be comfortable voting for because, just given the diversity in opinion from experts.
Thank you. Representative Reckett?
I am really interested to see what FLAC would come up with as alternatives and possibilities. I preface by saying, unfortunately, I agree with Senator Keim and Representative Moriarty that we couldn't possibly do a responsible job on a legislative piece in a week and a half. But I am very anxious to see what the options might be so that we could have, if we have a moment or two to ourselves, Lord knows when, have a little more discussion about the issue amongst the committee. Or if not, just enable those who might want to do something in the next session to have a reasonable starting place to look at what the issues are and what the possibilities are. So that, because I would hate to have us have this discussion today, which has got, everybody's brain ticking on this issue. And then, 6 months pass and somebody puts in a bill that may be crazy. I think it's, I'm not saying that anybody else might do something crazy, but I might do something crazy. I mean, I want some guidance from FLAC as to what would be a responsible series of decisions and possibilities that whoever puts in some kind of legislation should weigh before they launch into the effort. Much as I would love to have something happen quicker than the 131st, I think that it's responsible that it probably won't, whether we want to do it in a week and a half or not. We could do something slipshod in a week and a half, and that might well be worse than doing something in a responsible, contemplative way that we could introduce early in the next session. Those the we of who are going to be around again, and we don't know who that is right now. But whoever it is should have some guidance from people who have thought about this a lot more than we have at this point. So I would love to see if the members of FLAC are willing to articulate the kinds of things that Judge Kelly has spoken of. I think that would be a huge plus for anybody who's going to think about moving forward. That's
it. I agree with you. So much work has been done and so much thoughtfulness has been put into the subject. Even if as a practical matter, we're not able to move forward this session, I would hate to lose the momentum and all of the knowledge that we've received at this point. Representative Hagan, did you want to say anything or are you all set?
No, thank you, Madam Chair. I was just inspired by Representative Moriarty's thoughts and Senator Keim and also Representative Reckett. And I totally agree with what you just said. And from what all I've heard and read and whatnot, and there's a lot here, I completely concur and agree.
Thank you. So I have a question. I think I'll direct it to you, Judge Kelly. Do you think that FLAC could provide us with a supplemental report, a follow-up report that reflects the kind of, for lack of a better word, menu of policy options that you mentioned earlier? And do you think that we could prepare legislation asking you to do that, or we could simply ask if you would be able to prepare us with a supplemental report back. And Peggy, I don't even know if we're allowed to do this, but could we ask for a supplemental report that gets presented either to this committee in this legislature or to this committee in the next legislature? And Peggy will answer the technical question first.
So the technical question is they could submit it either like by March 31st or by December 15th of this year, in which case it would you'd give next session's judiciary committee authority to report out legislation.
Okay.
I've never seen one that actually spanned legislatures like that, but we could probably write that.
Okay, and if there were a way to, I guess I'm just wondering, even the concern about creating another bill that we would have to work on in the next 10 days versus just if we just asked for the report, the supplemental report by March 15th or March 30th or whatever, would that be an appropriate step for us to take?
I think that's probably a question for Judge Kelly about whether FLAC could work that fast, and then you would have to think about how you're going to deal with their report. Will you turn it into a bill? Will you have that referred back to committee for a public hearing? And whether you think all of that can happen. I mean, it wouldn't have to happen by March 11th, but it would have to happen probably by the end of March, early April, in order to get it done this session. So, I mean, I can tell you the legislative pieces of that. Judge Kelly can tell you kind of the brain version of that.
Okay, so Judge Kelly, what kind of a time frame would FLAC need to provide us with additional guidance?
I think, quite frankly, and this is I really want to say this, FLAC is an amazing group of people who come together once a month, totally on their own steam. There's no funds to do this, and we meet for 3 hours and we work really hard. We have an agenda, we do the work, but even with that, I don't think we could give you a really thoughtful piece of work next month because we just have one meeting before then. I think if you gave us over the summer, FLAC has the ability to bring forward a bill, and we're working on, hopefully we'll have a spousal support bill to bring it. That's another story. But what I can say to you as the chair of FLAC, and I'll still be the chair by December, is that we will undertake to come back to you with a bill to improve the preliminary injunction, and to the extent that with consensus, that's what I'll work for the next few months, to get everyone on board so we don't have any disagreement. To the extent that there's disagreement, we'll give you the menu. I like your approach, the menu, and you all will pick based on your values as to what that legislation should look like, but we'll write it for you so that you have the options and can easily do it. And hopefully you will all be back, but whoever's there, hopefully will want to continue to work on this. And in our report that we would come up with to accompany that legislation, we'll explain this process that we've already done. So the next people will know that, we're here, you gave us a job, we didn't do it perfectly, we talked to you, and this is what we decided we would try to do. But obviously that's a whole new group, and they'll either reject the legislation or not. But we would do all that work to get it to the next group of people, and hopefully it will be meaningful for them, and hopefully there's enough of you or all of you are on the committee next time.
Thank you. That's a really kind and generous offer. Let's see.
Yes. So my only concern is if, and FLAC will do an absolutely wonderful job because they are such an inspiring group of people that I've had the pleasure to work with over the years. But my concern is they would come to you in December, or not you, because it would be a different Judiciary Committee. So they bring to the Judiciary Committee in December a list of options. That's not a piece of legislation, and FLAC's deadline for submitting legislation is the start of the session. So it's that first Wednesday in December. If they're going to give the legislature choices, then I think what you might want to do is make sure that the Judiciary Committee of the 131st has the ability to use that information and report out a bill.
Okay.
So much like you did with 1102, you could do the same thing going forward for the next round. And FLAC is still doing the same thing. It's just you're not making FLAC come to the conclusion of which options to pick to go forward in order to get a bill printed.
Okay, thank you. That's a good clarification. I understand that's the right process to achieve the result that we want. And so, committee members, are we okay with Peggy drafting legislation along those lines that would accomplish us receiving the committee, the Judiciary Committee and the 131st receiving that report and recommendation? Representative Harnett?
I'm just curious, wouldn't that just be a resolve similar to the resolve that we enacted last year?
Yes.
Okay.
I think it would look very similar to that. And if that's actually what you wanted to do, and you're all, on the same page, it would not have to be referred back to committee for a public hearing. You could just report that out and it could go directly to the floor if that's what you want to do.
Thank you. So committee members, are we comfortable with taking that step? Representative Moriarty? We're not able to hear you.
Thank you. The answer to your question from me is yes, I am comfortable with that. The procedural question I have is, perhaps this goes to Peggy, are we able to make a motion in this procedural context that we're in this afternoon?
I believe you are. That resolve gave you the authority to report out legislation based on the report. You have the report, and the report is, we need to do some more work and generate some options for you. So I think that would be consistent. So yes, I think you can do that if that's what the committee wants to do.
Okay. Madam Chair, I guess I'll let the polling of the membership continue, and I'd be prepared to make a motion at some point.
I think you can go ahead and make the motion.
All right. Okay. All right. Then I move that we resolve to direct the Family Law Advisory Commission to continue the work that it began with the previous resolution, which I believe was Chapter 78 resolves, and that they report to the Judiciary Committee no later than, what did you say, Peggy, the first Tuesday of December?
That's when the new legislature comes in, is the first Wednesday of December, first Wednesday after the first Tuesday, actually. Right.
Should they technically report to us or the 131st?
I think technically they should report to the 131st if the 131st is the one that's going to report out legislation.
So continuing my motion, I'll say they report on December 15, 2022, and that the Judiciary Committee has the authority to report out a bill after having received that report.
Thank you, Representative. Is there a second? Seconded by Representative Harnett. Committee members, is there any discussion on the motion? I am not seeing any discussion, and our clerk, Subi Panet, has appeared to take the vote. Committee, ordinarily, we would move panel members, non-committee members off the panel, but I think we'll just proceed with the vote because we want to thank you once we're done with the vote. So if you don't mind staying with us for another moment. Thank you, Supi.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
Yes.
Representative Hagan votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Libby. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Evangelos. Representative Newell. I'll recall the absentees. Senator Sanborn. Senator Sanborn is absent. Senator Keim. Senator Keim is absent. Representative Libby. Representative Libby is absent. Representative Evangelos. Representative Evangelos is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 9 members voting in the affirmative, 0 in the negative, and 5 members are absent. That is the vote of the committee.
Thank you very much. And so the motion carries 9-0 with 5 absences. And we really want to express a tremendous amount of thanks to the FLAC members, to the FLAC committee, and to the 5 of you for presenting us with the report and for the really informative discussion this afternoon. I think when we entered the meeting, a lot of us had really no sense of where we were headed, and you've really helped us understand this topic tremendously, and we're grateful for your help and for your willingness to continue to work on it.
And I also say on behalf for FLAC and for all of us here, thank you, the chairs and all of you who participated in this discussion, and to Peggy for setting it up. And we love Peggy, as I'm sure you do. But we really appreciate that you took the time and the thought to engage with us, and we've really enjoyed the discussion. And we'll keep working. And thank you for your time. I'm sorry we kept you here so late.
We appreciate your time too.
Care, everyone. Bye-bye.
Thank you.
Thank you. Committee members, is there any other matters that we need to attend to this evening before we adjourn? Don't think so. Is there a motion to adjourn? Oh, Peggy?
Well, can I just say, I have not done the bill analysis for LD 1946 yet, which is on your schedule for tomorrow. That's the constitutionally adequate contact with counsel. It's Representative Harnett's bill. So I will be trying to throw something together really fast for you. I apologize. It's been a busy day. And I realize I'll try to put something together for you that will be as helpful as possible for your work session. But I think I've given you something for all the other bills.
Peg, is that the telephone recording bill?
Yeah, it is.
Yes.
Yeah. And it would be helpful to have something, I know.
Yeah, I haven't seen one on 1971 either.
I have it ready. I just haven't sent it yet.
Okay, great.
Yep. And I'm bringing it, yeah. And it'll be posted. Thank you.
All right. Thank you, everyone.
Okay.
Have a nice evening, and we will see you tomorrow morning at 10, I believe, right? 10 o'clock start?
Yes. That's what it says,
All right.
yeah. Sleep in
There
an
a
hour.
motion to adjourn?
So move.
And lots of seconds. Thank you, everyone, for all your great work today.
Thank you.
Thanks,
you
Ed.
all.
Good
Good
night,
night
all.
now.
Soupy, are you good with everything I got you? You think?
I am. Thank you so very much.
Okay.
I am just amazed. I didn't even get the chance to get off screen and I was already getting some. So yes, thank you very much. I really
Okay.
appreciate that.
Good. Thank you both.
Thank
Good.
you.
Thank you. Bye, Sue.
Yay.